As we get started today, we again are looking into DCFS and CACD and practice in removing children from the home and child maltreatment registry. Representative Neal, do you have any comments? Representative Neal is vice chair, is co-chairing today. Representative Herrmann had to be out of state, and I will mention the reason today because I think it's important. Many of you know that Representative Herrmann is a pastor, and he has folks in his congregation that are out of state. They have a 3-year-old child and grandchild who is having a kidney transplant. And Representative Herrmann, as a pastor, would travel with them to be with them and keep all of them in your prayers, especially this family and the child, that this will be successful. I believe that the next thing we need to do is the approval of the minutes from our October 28th meeting. A motion, do we need more than a motion? Second. All for approving the minutes signify by saying aye. Aye. All opposed? The minutes are approved. The chair will call Joseph Churchwell, Joe Churchwell, from Hot Springs. Stand. State your name and employer position.
Joseph Churchwell, I'm a solo practitioner, family law attorney from Austin.
Okay. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. You may proceed.
Thank you, Ron. On October 1st, we had a meeting of which this is a continuation. We heard from 5 different families that I represent. That was October 1st. What I'd like to do is just take a brief moment to bring you up to speed on what has happened during the rest of October. Those 5 families, I would like you all to keep in mind that those are not old cases that I have compiled over the years. All of those cases were active just last year. 3 of those cases are still active. Mr. Stanley's case is still active. The Brantley case is still active, and I have another Shepherd case now. In October alone, starting October 9th, I had 3 other domestic relations cases, all custody. One was a divorce, 2 others were born. Court, open cases active, and 3 of those received hotline calls within a 10-day period. And I'm a solo practitioner. I'm the only one in my firm that law in a relatively small town. In a 10-day period, I had 3 calls to a hotline that I had to deal with that were within custody disputes. The day before yesterday, I got my 4th one for the month of October. Also, a very acrimonious divorce. Also, litigation. One of the parents filed just a little over a month ago a motion for change of custody in that case, and that is the parent that made the hotline call. And I am assuming that information because it's easy to assume who made it. Hopefully that will be the first ever hotline call that is going to be referred to a prosecutor. We might make history with that one, I don't know. I think we have the evidence to push that one forward anyway. The reason I told you that is because I've said before, this is our 3rd time now that we've had this hearing, and that I have gone from cautiously optimistic to real faith that a difference is going to be made and that y'all are going to make some changes in the legislation and probably the protocol as well. However, I don't think that the families of Arkansas can wait until the 2017 legislative session for y'all to do something. My little practice, 4 already this month, 4 more cases since the last time we testified here. and we haven't made much progress as far as changing protocols or changing the investigation procedures or protecting the rights of the families. But I've had 4 more families to defend, just in October alone. I think, I don't know what the process is, but I think that this is an emergency situation. I've read a lot of emergency legislation in my career, and this is, I think, more important than any of the emergency legislation that I have read in the past. Families are being destroyed. There is a machine that was created by the government. Federal government now is being blamed for the confidentiality laws. There was an informal meeting that was called last week, and it was DHS brass and Arkansas State Police brass and Senator Clark, and I was present for about 10 minutes. Then they started talking about the Stanley case, my case. I represent the Stanley family. I had to leave the room so that they wouldn't violate confidentiality. Now they're saying those are federal laws and not state laws, or that our state laws parrot the federal laws. I don't know, but those laws are not protecting who they are meant to protect. So I got up and left the room. And I also noticed one other thing as I got up and left the room. I was the only person in that room that was not being paid by the state of Arkansas. In fact, the only person in that room not being paid. And I got up and left and sat outside for 40 minutes and wasted my time. I implore you to do something now. If you wait until the 2017 legislative session, we're talking probably 2 or 3 years before the new legislation, whatever you decide to do then, kicks in and takes place. I'm begging you to do something now. You have to create a real Office of Parent Counsel. You've got an Office of Chief Counsel. You've got billions of dollars to work with. And what we've done is we've created a system that oppresses families, that causes families to go bankrupt, that causes families to go to court in quasi-criminal proceedings without lawyers. The true finding, and again, I'm still right now concentrating on the narrow procedure of just the maltreatment reports. I'm not even varying over into the dependent neglect cases where the children are taken out of custody of the parents. I'm still on this just the maltreatment registry. Body cameras, there's about 200 investigators. A really good top-of-the-line body camera is about $500. For $100,000, you can put a body camera on every single investigator that's out there. It'll protect both sides. You need a Miranda warning. Instead of having investigators going out there and saying, we got a call on the hotline, we need to come in and see your child, or you need to bring your child up, and we want to come in and see your house, and we have a right to do it, they need to tell people, we really don't have a right to enter your house. And they need to be able to hand them a card with somebody that they can call, unless they have a warrant to go in there. If you could do those 3 things, and you could do those 3 things within the next year or 2, we might have a chance. If not, waiting till the legislative session to do anything about this, I don't know how many more families are going to be negatively affected. I say destroyed, and people think that's sensational, but it's really not. You don't ever get your family back when the kids have been taken out of your house for 2 or 3 or 4 or 5 or 6 months. What you get back is not your child that was taken out of your house, I promise you. Body cameras, a Miranda-type warning that we really don't have the right to enter your house, and real lawyers for parents is what's needed, and that's needed right now. That could be done fairly easily, and that's a start. And if we had that start, then we could wait. I think DHS is going to work with the legislature. I think that honestly they know that there are problems and they recognized it. The deputy director, I went to law school with her. I'm excited that Keisha's on board. She has reached out to me and said that we're interested in hearing this. But that takes a long time to do that stuff. There are 65 part-time parent counsel, or at least that was the 2014 list. I've got it here. So 65 part-time lawyers that help parents in dependent neglect cases, but only dependent neglect cases. Nothing to help us with the maltreatment investigation. I've asked, is there a, Your Honor, Mr. Chair, may I sound the room for parent counsel?
Okay.
Hey, Brian, this is the chief of parent counsel. I went to school with this guy too, law school.
Okay. While we've got it, we've held up here for a moment. Senator Irvin has a question.
I just want to, as protocol, you have a committee chair
Yes,
that
ma'am.
would be appropriate to clear any testimony that comes forward, and then it's really his role to call anybody up. I just wanted to make that clear, that this is a committee meeting with a chair conducting the meeting and not a witness conducting the meeting. So
I understand. That was
I
not
just
my
wanted,
intention.
okay.
I
I
merely
just wanted
wanted
to
to know if
clarify
they
that.
were
I
here.
will have questions later, but that's appropriately how we run a committee, is that the chair would then, if you have a request, then the chair could then request somebody to come to the table with you.
Thank you.
And I want to state that because I respect, my colleagues, and I respect the committee structure and the way that we're supposed to operate these committee meetings. So, thank you, Mr. Chair.
Thank you. My intent was merely to find out if they were here or how many were here, so I apologize.
Thank you, Senator Irvin. Let me take this opportunity to, say that we all understand that I appreciate Mr. Churchwell's passion, that anything that we would do legislatively, if we did it before 2017, and I certainly have not called for that, to be clear, it would require the governor calling for a special session. We all know that. I think Mr. Churchwell is referring to the fact that there may be policy changes that can be made between now and then. But let me go back to part of my opening statement from the last meeting on this that I did not cover today. There were 3 questions that I wanted to look at, and I'm going to add a 4th today, and there's probably more. But are there problems with the way the state of Arkansas handles child abuse, negligence, and maltreatment cases? Number 2, are there problems with the laws, privacy and otherwise, that surround these cases? They are supposed to protect families, parents, and children. Do they not sometimes instead protect government agencies? Number 3, are we skirting constitutional protections by substituting true findings for finding folks guilty? Instead of the state proving a case, it becomes the defendant's obligation to prove they are not guilty. At least in a criminal case, the state has to provide an attorney if you cannot afford one, but not in a child maltreatment case. And then I'll add number 4 today. Are there problems with having 2 separate agencies, CACD and DCFS, that there is no one that can, from what I've been told, maybe we'll hear differently today, that can overrule one from the other, 2 totally different heads. And there's probably other questions that we will come up with. So those, and it is also the chair's intention when we finish with this, not today, but when we finish with this, that we will issue a report of what we have found to the governor, to the task force that has been instituted on reform in this area, and also to Children and Youth Committee for them to take any actions that they might want to take, because our job here, as we know, Representative Hammer read it at the last meeting, is to review, to investigate and review. And so that is what we're doing. Okay, Mr. Churchwell, you said you just wanted to know if someone representing who?
Parent counsel.
Parent counsel was in the room. And
Parent counsel are the adversaries to the Office of Chief Counsel. The Office of Chief Counsel represents the investigators and/or the Department of Human Services. Parent counsel represents really only indigent parents. I have a client. I'm going to take it. He contacted me, said he's on disability. He makes $900 a month. He was turned down to have parent counsel because he was not indigent and he has $900 a month income. There are about 65, I think, parent counsel. When I say real parent counsel, I mean real resources, real money, real help for them. What parent counsel are, and correct me if I'm wrong, are all part-time, solo practitioners generally. They don't have to have a lot of practice experience, courtroom experience. Is it a 10-hour class, Brian? You go to a 10-hour class and you're parent counsel. That's not good enough. We're going up against people that have been in that agency for 20 years. We're going up against laws that are stacked against us. We're going up a lot of times with true findings into a dependent neglect case and not have the resources to do, and so many of these are simply custody issues. The agencies have been wielded as a weapon because there is no recourse for doing that. People have nothing to lose to make that hotline call. All they've got is something to gain. There have been studies about, you heard Dr. Visor, the SAID syndrome, sexual abuse allegations in divorce. There's also a PAID syndrome, physical abuse allegations in divorce. He gave figures that 46% of female litigants in custody battles make some type of a sexual or physical abuse allegation during the course of that divorce. There are studies since the mid-'80s about these syndromes, and all of them urge a different course of investigation for maltreatment investigations that include custody litigation. In other words, there's one set of protocols for investigating a maltreatment report that comes from somebody other than a spouse that is in custody litigation, and then there is another one to take in effect that. There is absolutely no distinction in our protocol in the investigation of a maltreatment investigation in the midst of custody litigation versus one that is not. Everything is the same. The only prayer we have is a private attorney that knows a hotline call has been made to reach out to that investigator or the supervisors and say, look, here's the link to the docket sheet. This has been in litigation for 2 years. The complaining party, or who we believe to be the reporter, has just filed a motion for change of custody. We have to bring that to their attention, and we really shouldn't have to, because all of these documents are on the AOC. If they would take that into consideration at the hotline, and so that we know what we're getting into. There's not been a study done that doesn't urge a different course of investigation when the allegations are made in the midst of a custody battle. We're behind the curve in Arkansas, and we're also ahead of the curve. You mentioned the fourth question, Mr. Chair. Should we have two different agencies doing the same thing? Well, no, we shouldn't. Should we have police involved in child welfare? Well, no, we shouldn't. Are the social workers helping people? Well, no, they're not, because the people are scared to see them. If they were coming to help people, people would not be scared of them. And people are scared to death of the state police in the maltreatment investigation. It's all too common to use that as a weapon. And I just implore you, please think about the families. Once you start a battle with a boot on your neck, you're not going to be able to come out of that 9 times out of 10. I have luckily turned a few of them around, but it has cost the families so much in money, contact with their children, relationships with the family, extended family, siblings. When they use the system as a weapon and you get started out that way, it's a nightmare. Like Mr. Chair said, God help you. And that's exactly where we're at, and I'm hoping for some help before the next legislative session.
Okay, Mr. Churchwell, you've raised some number of other questions. Is the deck stacked against the accused, anonymous calls, and custody cases? And we have some questions. Representative Fott.
Thank you, Mr. Chair. I believe I'm going to hold my question for CADC.
Okay. And Representative Broadway. No, push it again. Push the yellow. One time. You're good. There you go.
Thank you so much, Mr. Chair. Appreciate it. It's taken the seriousness perhaps out of my questions. Mr. Churchwell, I really appreciate the plight and the problems that you have brought before this committee. I was a family law attorney for about 20 years, and I've sat in your shoes, and I've represented parents, I've represented children, and been on both sides of this coin. And I recognize that there are significant abuses in custody cases with regard to one parent making allegations against another. However, I really do have some concerns about some of your suggestions with regard to giving parents Miranda warnings when these are not criminal proceedings, ensuring that people are not allowed to enter homes where there could be definitive, real problems with those homes. And it seems like to me that perhaps you're making the argument that we are going overboard against families and parents, but what we could be losing are protection for these children who otherwise do not have protection. And I really want you to be thoughtful, and if we do something here, recognize the potential ramifications that children could suffer greatly if some of these recommendations are made. And, you did the quotes about, 46% of female litigants in divorce cases allege some type of sexual or physical abuse. And the fact of the matter is probably, and I represent a lot of men and defend a lot of men against allegations like this, and I know they're abused, but there is a huge problem with spousal and domestic abuse in Arkansas. And we have to be very careful and thoughtful as a legislature that we do not leave victims of abuse without the protection that they need under the law. And so, in these recommendations, how serious are you taking that side of the issue? Because of everyone, adult women that may be victims of abuse, children are our most vulnerable and least protected and cannot speak for themselves. And so I do realize and recognize the seriousness of the issues that you are addressing, but I think that you in your recommendations and we as a body have to be extremely careful about what we do with regard to how children are affected here.
Thank you very much. I agree totally. I've been working on this for about 8 years. 4 of the families that you heard from, I had already put together and contacted Senator Clark. Then the Stanley family tragedy happened. This isn't something that I've just started in January. Literally for years I've been trying to tell people what's been happening out there. Most people don't believe it. I wouldn't have believed it had I not experienced it. The problem is that there is a fine line in that there are children that are in danger and there are children that are being abused. I think the senator said it very well last time, that is protecting children so important that we have to ignore the constitutional rights of all of the others or of the parents. And I think that's one consideration. I think what we are not considering is that those children have constitutional rights right now. Those children have a constitutional right to be raised by their parents in a family situation that the parents believe is right for their family. And if they're not abusing their children, if we're coming in and removing those children and causing the trauma, then we have ignored that child's civil rights too. And everything has to do with what's in the best interest of the children. And it seems that whenever anybody says that, whether it's an ad litem or a judge, said, well, it's in the best interest of the children. Well, there's not even a loose definition of what that is. What the best interest of the children is a vehicle to put on the end of a case to justify whatever decision the court made, because if you didn't put that label on there, then the court would have made a decision contrary to the law, because everything must be done in the best interest of the child. But it is so vague. We're forgetting that that child has constitutional rights, and those constitutional rights are violated when an investigator or a police officer goes in that house and removes them from their family if it's unjustified or unwarranted. And so it's very delicate balancing. I didn't say Miranda warning, I said a Miranda type warning. And I don't see any problem or any danger in a state official or an agent of the state telling a United States or an Arkansas citizen what their rights are. Instead of going up there and saying, I've been charged with an investigation and I have a right to enter your home, which is what the statute says, they say that a lot of times with a police officer behind them, and it gives the impression that they have no choice but to let that state agency in their home to do whatever they want. And the dangerous part is, if I make a hotline call for bruising, and that person goes to that home, the investigator, whether it's the Crimes Against Children Division or DCFS, they go to that home, they're going to start the investigation either within 24 hours if it's a priority 1 or 72 hours if it's a priority 2, and then they're going to forget about the investigation. They're going to stop the investigation right there. They're going to pull out their book and their check sheet, and they're going to go to the 14 Arkansas health and safety factors. And they're going to do a complete evaluation on the entire home, all of the children, all of the parents. One of the health and safety factors is the parent overly negative toward the child. Okay? These health and safety factors, if you want to find them, you're going to find them. You can find them. You can find them in any home. And again, I'm trying to be clear that I'm concentrating just on the maltreatment investigation, but it stops there. And then we go and we look at the whole home. We look at all of the children. We look at any reason, any excuse that we can provide services. And don't forget this fact. The child welfare industrial complex is a business. And it's not just a business. You've got doctors, you've got lawyers, you've got counselors. We now have child abuse specialists in the hospitals. You have the children's hospitals. You have foster homes. You have orphanages. Doctors. Don't forget the lawyers. And then our experts. We rely so heavily on experts. If an expert says it, well, then it must be true. These experts are counselors, doctors. They're an expert, so they get to give their opinion. That doesn't mean that it's true. It doesn't mean that it's correct. It doesn't even mean that it's factual. But we rely on the experts. I've never seen a judge, especially if it's their expert. Judge appoints the expert. I've never seen a judge question that. Rarely have I seen a judge question the recommendations of the Department of Health and Human Services. They all work together. They're all under the administrative office of the courts. Mr. Chair, may I have some water?
Yes, and let me, Representative Broadway, do you have a question? I've got some lined up behind you.
I defer to whoever wants to
Okay.
ask another question. I think he has certainly, I guess, answered or addressed my concerns.
Okay, well, feel free to chime back in.
I've had many people tell me last week even that they wouldn't want my job. I wouldn't want that job because it's a tough one. It's a very, very delicate decision that y'all are going to have to make.
Representative Gates.
Thank you, Mr. Chair. Mr. Churchwell, I asked a question of the state last time we were here. I did not get a satisfactory answer. So I'll ask you, in your opinion, when bad parents are doing things that justifiably cause the state to come in and remove children, i.e. they're beating them, they're burning them, they're poisoning them, they're all the things that we deem as a society as inappropriate and not a place we're going to leave kids subject to. That even in those situations where the state comes and takes those kids, even where we're justified in doing that, there is trauma to those kids just because they're in unknown familiar areas, they're in homes they don't know. It's a whole litany of trauma that kid goes through. Had the parents not been bad parents, the state would not have been justified in taking them. So in this case, that trauma really is a result of the parents. And that trauma, how tragic that is for the kids, is really as a result of parents' bad decisions. Would you agree? Do I need to clarify that?
Let me see if I got it, if I may. Whether or not it was justified?
No.
No.
If it's justified.
That-
Parents are beating their children.
Yes.
Parents are burning their children. Parents are burning their children. They're sexually abusing the children. The
Take your
state
kids
comes
away and
in.
you don't give them back.
Okay, and the point is this is where we find parents are guilty, and those, even when it's guilty, there is trauma to those kids by just taking them out of to protect them. Is it not equally damaging and traumatic to those two kids who are taken out of the home and then later on discovered that the parents weren't beating, weren't poisoning, weren't sexually abusing, were not traumatizing their children? Is not that trauma still affecting those children?
It is, and that trauma is not the
And
fault of the
would you
parents.
not say at this point now that the state has become the perpetrator of the emotional damage to those, set aside the parents, their constitutional rights and due process and all that, would you not say that that damage has now been done and now the state has become the perpetrator?
Yes.
So
And-
the goal here is not to minimize or anyhow ball up the system that takes kids that are in bad situations out. But in effect, how do we minimize the damage done when the state makes the mistakes and now the state has become the perpetrator of the damage done to innocent children and families?
Yes, I'm going to be honest and I'm going to be frank with everybody. You're going to ball up the system a little bit. You're going to impede the efficiency of this system if you do the right thing, because that's what the Constitution does. The Constitution puts limits on a government as to what rights they may violate. Right now, and they'll tell you that a supervisor helps make the decision. Even if it helps, still the investigator is from A to Z. They start the investigation and they decide guilt. Now, if a supervisor signs off on that, then that's great, good for them. They are not doing the investigation. They're not going back through and doing all of the work of the people under them. They're trusting that call of the investigator, which they should. The problem is that investigators shouldn't be able to do all of that.
So let me ask you one more other question, then I'll turn that over. So in your recommendation for a Miranda-type warning when an officer or an investigator shows up at the door and says, we're here, we have a right to investigate, we have a right to come into your house, you're not suggesting that if somebody physically saw somebody, raping their child or stabbing their child, that the state is supposed to, at that point, because you're talking about, what we're talking mainly is about hotlines where somebody's making an accusation that is going to require an on-site investigation that's not just a short look and see.
There are all kinds of ways to get around a search warrant. The biggest one is an exigent circumstance. If you walk up to a house and you hear a child in distress, or you see blood, or you see something like that, a warrant's not required of anybody in any situation. If there's an exigent circumstance and somebody's in danger, you go right in. I'd be the first one to kick down the door to do it. The Miranda warning should just simply say, we've received an allegation, this is what the allegation is. Then they should say, instead of, we have a right to come in and investigate and you must bring your child to me, you can say, we would like to see your child. We don't have the power to come in without a warrant. Just like saying you have the right to remain silent, you have the right to an attorney. Anything you say may and can and will be used against you. I would like that in there. Anything that you say, anything that we see can and will be used against you. It's not a criminal proceeding, but it's at least a quasi-criminal proceeding with ramifications that are often worse than a criminal conviction. Many of these, you can seal a criminal conviction, even felonies, even violent felonies after a while. You can't seal this if you're on the child maltreatment registry, especially if you can't work for the state anymore. You certainly can't work around children or disabled people, and a lot of these people have licenses. You heard from 3 of the 4 families that I brought up here, professional licenses, that their actual livelihood was in danger. And not only did it affect the children that lost the relationship with the parent that was accused, it also affects those children that are step siblings and children of new spouses. Because when the husband doesn't work, the bacon doesn't come home. And that's hurting children. There is no easy answer, but there's a no-brainer. You don't violate people's constitutional rights, and you have to start understanding that the children have rights too. The children have rights to not be taken out of their home, taken to a strange place, not know when they're going to see their parents. These confidentiality agreements, Mr. Stanley could not even have his 1 hour of supervised visitation until he signed an agreement stating that he would not talk to his kids about the case. Yet when he gets there, everybody from the state has talked to the kids about the case all day long, and they're going to talk to him again right after he leaves. Why can't the parent talk to the kid about the case? Why is everything done secretly and in secret proceedings? Who's being protected? You can't ask it any better than the senator has asked it. And these are just common sense things.
Okay, Representative Gates, are you done? Okay. Senator Ervin.
Thank you. You had mentioned about the laws, that you made a comment on the federal laws or the privacy laws that you don't know what they are. And that's what you had said. So, are you referring to the federal laws of like FERPA and HIPAA?
No, I'm sorry. Are you ready?
Yeah. I mean, just a
Title-
quick
title-
question,
right.
okay?
Title
so,
4E of the Social Security Act.
Okay, so federal law, which we can't change here in this body. State
I-
legislature cannot change federal law.
This is what's being
Would you
cited.
agree with that?
I agree. I don't think
Okay.
that it prohibits what we're asking. I think that there's no
Okay,
case
so-
law.
So that's interpretation of the law, though, which is what,
That's-
you
there-
ask 20 attorneys, you're going to
Right,
get 20 different
exactly.
answers, right? Okay, so
Exactly.
I just want to be clear about my questions.
And that would be Title 4E of the Social Security Act.
Okay, so I'm sure that I'm sure I could probably get 5 different attorneys up here, and they would give me they would give me 5 different opinions probably on those privacy laws.
At least, maybe more.
Right, okay.
Right.
Okay, but I just want to be clear that state government, we cannot affect federal law changes.
Yeah, but they disobey federal law all the time. Right underneath where it says you have to have confidentiality, it also says that relatives will be given precedence over non-relatives as to placement. That doesn't happen in Arkansas. They violate that one every day. They don't have a problem with that. They don't violate the ones they don't want to violate, but they'll violate the other ones. And I don't think there's ever been one case where the $70 billion wasn't given to the state as a result of not placing the kids with relatives. And that's in federal law.
Okay, well, again, we're using big, wide brushes here, and I'm very uncomfortable using big, wide brushes when everyone or they don't follow the federal law. Specifics, I think, helps us get to a conclusion and work, okay?
But the laws prohibit specifics. We can't talk about a specific
I'm talking
case.
about specific. You're using broad brushes.
Lisa
strokes.
McGee said that we cannot violate the federal law. Is that specific?
I'm saying you're using a broad brush, saying that they violate federal law all the time.
Well, the
And so,
governors,
again, I want to make sure that we're not using a broad brush.
that's what the governor's report said, is that Arkansas is way behind the other states in putting people with relatives. And there has been evidence and incident after incident after incident where fit grandparents.
Correct, but we're talking about privacy laws. My questioning was about privacy laws, okay? Not about
Right.
what you've brought up. My question to you was about privacy laws.
I
and
thought it
you
was about
said-
violating federal law.
My question to you was about privacy laws and about what we can change and what we can't change.
Yeah.
That was my question to you. Number 2, my question to you is, you had spoken to, do you have exact policies that could be changed? Because unless the governor calls an emergency session, legislation cannot change. So are there specific policy changes that you would recommend?
Yes.
Okay, and they are?
First one is I would have the Office of Chief Counsel designate attorneys to make the findings, whether it's substantiated or not. You have to remove that one element from the investigators to even argue with a straight face that there's integrity to the process. One person can't do it all. One person can't be the cop, the investigator, the prosecutor, the judge, and the jury. That's not human nature. You need somebody that understands burdens of proof. They will come in here all day long and say, well, my burden of proof is preponderance of the evidence, and what that means is more likely than not. But the problem is, there are several burdens of proof, and if you don't understand all of them, you can't just pick that one little thing out there.
Okay, so you have a list, and I'm sure that the state will be able to respond to that, the department will be able to respond to that. The third thing was, you had talked about this being a money-making business, and there's a lot of folks that do not make money on this, that do report, they do. You again used a very wide brush, talking about doctors and lawyers and experts and blah, 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 blah. Well, there's a lot of folks out there that do a good job and don't make any money doing assessments and physicals and intakes and all that kind of stuff. So I would just tender just to caution you on kind of using a broad brush that, the whole system's corrupt and everybody's, making out like bandits and kings based on this. That's just a little over the top and not necessarily the case.
I don't think I said either one of those things at all.
And your
in the last
comments
few
were
days.
very broad.
Yeah.
The other thing was, I'll give you an example. I kind of want to hear your response to this is, there seems to be, and you brought up the custody issues, there seems to be, my fear is striking that balance. I want people to call the child abuse hotline. I don't want people not to call it, because and so to me, the crux of the matter becomes the investigation and how that procedure and how that process occurs. I'm going to give you an example, and I'll let you respond to this. We had a situation in a school where they hired an individual to work at that school. There was no criminal background that appeared. They did a criminal background check. Nothing appeared criminally on this person. They hired the individual, and one of the teachers at the school would stay after school to study to obtain a master's degree, and her children were there at on the campus. And her children eventually they were groomed by this person who was sexually molesting her children. Nothing appeared on this person, but the person was on the child maltreatment registry because it was a domestic situation. It was never reported. And this person had abused members of his own family, but no charges were ever brought against this individual because it was domestic, because there were threats made to the children that he abused in the home, of his own home, that he would kill them if they pressed charges against him. So there was no criminal charges, there was no criminal background that showed up. This individual was hired at a school district, at a public school, and then proceeded to sexually molest a teacher's kids. So we worked to make sure that schools, public schools, check the child maltreatment registry before they hire somebody to prevent a circumstance like that happening. So I want to get your response to that situation, because that's kind of the other side of the coin from what you're discussing. And I understand, you see the different side, and I respect that different side. I'm just also saying and presenting this side of it and what your response is to that.
I mean, that's what the system is designed to do. That's what happens when the system works right. He was an abuser. He's on the maltreatment registry. Is this happened before the schools were required to check the maltreatment registry?
Yes.
Okay.
Before we changed the law.
Well, then that's great that you changed the law, because that's really the purpose of the child maltreatment registry, is to notify people of dangerous people. The problem is there are dangerous people out there that should be on the maltreatment list that are not right now, and I could name 3 or 4 of them.
But some of your suggestions on, asking if you come to the house and saying, can we see your child, that parent's going to say no.
Good.
But what if that parent is abusing their child?
Well, then, if that parent
then no,
is abusing...
that's not good.
Okay.
Do you see what I'm saying? And
do.
if you present at a child abuse hotline, a phone call is made, and then they go to the house to investigate, and it's the other side, and it's an extraordinarily abusive father that is sexually molesting and raping the child, or a stepfather, or a boyfriend, or whatever, and the call is made from a health professional, a teacher, a neighbor, somebody like that. Then they go to investigate, and then under your suggestion with a Miranda right, or what you're suggesting, that can we come in and see your child, and that parent says no, you cannot, then what? Then do we result in a death of a child?
No. Well, maybe. I mean, it's not a perfect system.
Well, maybe.
Nobody,
is that acceptable to you then?
It's not acceptable to me, but I don't think that there's anything in the real world that anybody is going to be able to do that's going to save every child. Abuse is going to happen, okay?
But so you don't believe that we should try to stop that abuse?
I do, but I don't think that we should trample all over the Constitution to do it. I don't think that we should mislead parents as an agent of the state to come up to the house and mislead them into believing that they have a right to come in without a warrant. I mean, if we have to mislead our citizens to protect the children, then we might as well change the Constitution and say that you don't have to have a warrant to go in if a child is in trouble, or if you have a call that alleges a child is in trouble. I mean, if you really want that power to do it.
I guess so. So you're saying that the call itself needs to be investigated more thoroughly.
I think the intake should be. The actual hotline itself, they've got 24, they've got a lot of full-time operators. There has to be, and study after study has said it, when you have instances where they are likely to abuse the system, where they are likely to use the CACD or DHS as a weapon to either, and you know how it can be used. And if
Sure,
there are-
I'm
if
not
there-
denying that it's used as a
Right.
weapon, sure.
Right. If there are red flags, well, then let's kick in a little bit of a different protocol. Let's see how long the legislation has been going on. Let's see if there is a history of false reports. In one of my cases that I hope will be the first one that is prosecuted, there is a history of false reports made to a criminal entity, and that's why I'm going to push it. We might actually have one at least turned over to the prosecutor. That's a victory to me if we can do that. If one person goes to jail for making a false report, you'll get the whole state's attention in a minute.
And the current law, does the current law on, there is within the statute a consequence for that, is that correct?
$2,500 fine, up to a year in jail, or both. It's a Class A misdemeanor. But the
Yes,
problem
that's
is,
correct.
you'll never get someone
I believe.
in front of a judge. That's correct. You never
Yeah.
get anyone in front of a judge unless those investigators from CACD or DHS refer those charges to a prosecutor, because I don't know who the reporter is. We know by law that none of us know who the reporter, only the investigator and the hotline people know.
Correct.
So
Right.
they are the ones that have to make that referral.
Right.
This caseworker said, yeah, I believe the child was coached. I think that it's a false report. I said, then turn it in. And she goes, you do it. I said, I can't. I don't know who the reporter is. It's your duty to do it. And I think they're going to step up to the plate and do it. And if they do, I'm throwing a party, and I'm going to tell everybody.
Well, there's no harm in referring and then
But they
letting
never
folks
done it.
investigate it. Well,
Major Staten testified here that they have he can't recall one.
and
out of-
unfortunately, and unfortunately, there are a lot of instances, the case in Arkadelphia, there were so many people that could have and should have called the hotline on that incredibly abusive situation that happened in the school at Arkadelphia, and nobody did call the hotline. So you have problems, across the board on this issue.
There
Not
are
denying
criminal- there are-
that. But thank you for your question.
There are criminal
Thank you for your time.
consequences for not turning them in, too, as a
Thank you
mandatory
both.
reporter.
Senator Irvin and Mr. Churchwell, I think, did a great job of bringing up both sides of this. I was going to try to be done with Mr. Churchwell by 2. I've got 2 people in the queue, and so we're going to go to both of them. Representative Lowry.
Thank you, Mr. Chair. I do appreciate you calling on me, even though I'm not on this committee. Mr. Churchwell, I want to thank you. I know it's not easy to come before a committee, and especially when you're emotional about an issue, and try and be concise and clear. And I also want to apologize to you, because I think the last thing this committee should be doing is trying to undermine your credibility on an issue that is so critical. Yes, it may be true that you've painted with a wide brush in some situations, but until you've actually been in those situations, you don't really understand. And I can tell you that I've been in that situation. My son, who's now 25, experienced an unfortunate accident in our house when he was 1. His leg was broken, and it was an accident. But we were treated like criminals. When we took the child to the hospital, and I'm not going to name the hospital because there was malpractice involved in the hospital's complicity with this system. A doctor told us after the child was put into traction that I asked him when was his leg going to be set, and he said, well, there's no real hurry since there's an investigation going on. And I said, wait a minute. Let me understand this. Are you telling me that you're withholding treatment because there's an investigation going on? And all of a sudden, the doctor got pretty fearful about being part of this process. When we were told, when his leg was set, and we were told he was free to be released, we were told that DHS was going to be there at the hour that we were to be released, and we're going to put a 72-hour hold on the child. So I can tell you through having lived through that, and I'm someone who somewhat understands, even 24 years ago, understands the law. I was fortunate that I had a friend of mine who was an attorney who did not charge me an arm and a leg to protect me. But I can tell you that this system is overzealous and has to have some constraints. This is not new to our government. Benjamin Franklin spoke about the balance between liberty and security, safety. We have to protect those who cannot protect themselves, but we don't do it by stepping on the liberty of all Americans, of all Arkansans. There's got to be a better way, and I think some of the solutions, some of the suggestions that you have offered, especially the Miranda-like warning, because many people don't know that they can say no. They don't know that their home is their sanctuary, that they have protections. So I know that that is a statement more than a question. I'm not going to ask you, would you agree? But I would ask if you have any other information you'd like to share with us, especially about the 72-hour hold, which can be done really with very little evidence presented to a judge. Is that correct?
It can be done with no evidence presented to a judge. Basically, the caseworker or the police officer will decide to take the hold, and then there will be a probable cause hearing wherein you're in a courtroom with the circuit judge, but hearsay is admissible. The rules of civil procedure and the rules of evidence don't apply, again, because we have to protect the child. So, and correct me if I'm wrong, you might get parent counsel appointed to you at the probable cause hearing. Is that correct?
But that is after the 72-hour hold. At the 72-hour hold, the parents are not even notified.
And it may be within that 72 hours that you have the probable cause hearing if you're really lucky. But what I'm saying is you've already had people in your house. Your child is in state custody. You're before a court defending yourself against very, very good trial lawyers. I mean, the top of the notch that you've got up here for the state. You know, a lot of times I'm out of school 6 months when I'm doing it, and then I'm appointed in the middle of that hearing or during the hearing, or if I'm walking through the courtroom, the judge says, Mr. Churchwell, come here. This is so-and-so, meet your new client. Sit down and try the case. Tell me that doesn't happen. But it does happen. And it does. And these lawyers have no resources. These lawyers are all over the state in a little office, you know, solo practitioners. Anybody that's turning and burning really is not going to take this job. It's people that are new that need the job, or it's people that have been there a long, long time and they've got 2 or 3 contracts. There's something that really worries me about this. I've got a list of the parent counsel here, and I personally know 4 of them that are prosecutors. Matt Sanders, I'm not going to name them, but they're prosecutors. You cannot tell me that I can on Tuesday work for the state and prosecute people of the state of Arkansas using law enforcement that works for me, because law enforcement works for the prosecutors, and then turn around on Thursday and zealously represent the very same public that I prosecuted yesterday and cross-examine the very same investigators and police officers that I used as a direct witness the day before. You can't be a public defender and a prosecutor. I think there's a conflict there, but it just goes to show you how ridiculous the amount of resources are put on the state side versus the parent side. There's nothing. We have a full-time office, but we don't have regular training. We've had 10 hours of training. I didn't even know that there was somebody in charge when I was one. Didn't know it. They don't tell you. There's no resources. If I'm in office of chief counsel and I need help, I call one of the 20-something paralegals that are there. I call David Sterling. I call Lisa McGee. I get help. They've got help. We have no structure. There is no office of parent counsel. Right. And y'all have got to, well, I say y'all have got to. It makes no sense to me that you're taking these parents' tax dollars and creating a machine that they can't fight against and giving them basically nothing.
And let me say, just in closing, I agree with what Senator Irvin said, that there are 2 sides to this, and I experienced that even while I was in the hospital with my son. In the room next to him was a young man, a little boy, who had been purposely scalded in a hot tub, thrown into a tub, and needed the protection of the state. But yet, we were in a situation where it was purely an accident. Purely an accident. And we were under the microscope while we were visiting our child. They made sure that the nurse station was constantly watching us, and there's nothing more terrifying than knowing that your child could be taken away from you for absolutely no reason. So I want to thank you for bringing this to light, and hopefully we will be able to make some meaningful reforms. Thank you. Thank you, Mr. Chairman.
May I say one thing about your first statement? You're absolutely right about the trauma of the separation. Representative Gates was also correct. Whether there's abuse or not, even the homes where there is abuse, removing these children if it's not necessary, and it's not necessary to remove every child because there's abuse. There are going to be instances where the removal and the separation and the syndromes that come out of that and the unsurety and the disruption in the child's life, you're going to compound that to already being abused instead of taking it on a case-by-case basis. You cannot remove a child from their parent for 72 hours and tell them you don't know when they're going to come back or when they're going to see their parents, and you can't keep parents away and give them 1 hour of supervised visitation a week without destroying that family and without endangering the relationship between the parents and that child, and without completely destroying the faith that that child has in their parents to take care of them and protect them, because they see their parents standing at the end of the hallway waiting for that social worker to tell them to come down and they can have that 1 hour of supervised visitation, whether they're a danger or not. And that also carries over to grandparents. Grandparents a lot of times want to step in and take care of their children when their parents have dropped the ball. And we know the governor's report, there were 2 things that came out of that I think were worthwhile. One, you remove the Office of Parent Counsel out from underneath the administrative office of the courts. Right now, the AOC runs everybody. Both sides are under the same thing. That was a good suggestion from the governor's independent report. Make them their own entity. Don't make them beholden to anybody. I've got people that are supporting me with all they've got silently, but they're scared to come down here and say it in person because they might want to go back to work for DHS. They might want to work for the state. They will not come out and publicly say it. They're too scared to do it. And there's a good reason for that. It's hard to make a living out here, especially us that are solo practitioners. I'm out there scratching every day. Now I'm doing more pro bono work because of this than I'm billing for. People need to take care of their kids. Lawyers have to have jobs. The state provides a lot of jobs for lawyers, public defenders, prosecutors, DHS. You don't bite the hand that feeds you. People are scared to say what the truth is. They're scared to offend somebody because the state is so powerful. There's also one other thing I'd like to address. There are now child abuse specialists, MDs, doctors in these hospitals that do nothing but look for child abuse. I'd just like you to think about that. They're not healing people. They're looking for child abuse, and they're called specialists, and they're one more expert to add to the arsenal to fight the family.
Representative Lowry, were you finished? Representative Scott.
I don't think, okay. Thank you, Mr. Chair. Mr. Churchwell, first of all, to you and to anyone who may be in the audience today who has been directly affected by this suffering, I do not want my comments in any way to lessen your pain. My heart truly does go out to you. However, my 5-year-old granddaughter asked me the other day, she said, "Gigi, if you had a magic wand, what would you do with it?" I immediately said, I would make every child in the state of Arkansas safe. And that's safe from parents who abuse or safe from other abusers. However, I don't have that magic wand. We were playing pretend. Too bad we didn't. My husband and I were very fortunate. We raised 4 children. At no point in time did anyone ever come to our door, no officer, no one from DHS, and say, "Mr. and Mrs. Scott, we have a complaint. We'd like to come in and check." But I'm going to tell you something. Had an officer or someone from DHS come to my door and said, "We have a complaint, may we come in and check?" I would have said, "Yes, sir, yes, ma'am, you come in right now, please." I think parents who do not allow authority to come in immediately send up a red flag to our officers or to our people who are in authority and are in charge of checking on these families. Am I wrong about that, Mr. Churchwell?
I don't think that exercising your God-given innate civil rights should send a red flag to anybody. So if you're asking my opinion, yes. I think that you're wrong about that. I might have, before I knew the system, said the very same thing. You come right on in and you look around. Now that I know their tactics, now that I know the protocol, now that I know what really happens when you open that door and let them in, I wouldn't let you in my house without a warrant for anything in the world.
Can
And I
you
would
give
not
me
tell.
the list of 10 names of folks that you believe work for these entities who have wrongly and unjustly accused families? Can you give me that list today? Can you give me 5?
Well, I work primarily.
Can you give me 5 names?
You have to understand there are
Excuse me,
200
just-
investigators.
Excuse me just a second, Mr. Churchwell. Sir, you're out of order.
I'm sorry.
I'm not talking to you, I'm talking to the gentleman back here. We will be dealing with the witnesses we have up here. Any information you have, you can try to get to Mr. Churchwell or to somewhere else, but if we don't practice the decorum that we expect in a legislative committee, I'll have to have you removed. Okay, go ahead, Mr. Churchwell.
I'll give you 2 names right now that I believe have wrongfully done it out of either spite or anger. I haven't had contact with, trying to think now. I see the same investigators time after time because I primarily work Garland County. Yeah, I'll give you 2 names. I can't give you 5 because I don't know for sure. And when I make that kind of an accusation, I want to be sure I could prove it. I think 2 of them right now.
Hold on just a moment. Do you really want that answer?
I'd like to have that answer after the meeting is over.
Okay.
Thank you.
Thank you.
I will.
Okay. Okay, I'm going to take Representative Sullivan. Where are you? Okay, well, I was going to end with that one, but I'm going to go ahead and take you. I'd really like to move to the next witness. Go ahead.
Yes, sir. Is it true that 50% of the true findings by the police were overturned?
45% of the true findings that were appealed in 2015 were overturned.
So although we may not have the names of those people, we do know that those investigations, when there was a true finding, almost 50% of those were overturned.
Right, but I think what the Congresswoman was asking is, do I know for sure that they were wrongfully, that these true findings were done, I guess, with knowledge that they were not true? And I think I know 2 people have.
Okay.
But,
Thank you,
but
Mr.
those
Chair.
others could be simply mistakes or incompetence, or, I mean, there's a lot of reasons for true findings.
But
to
the
be
impact you described on the children
Mhm.
and the family, whether it's a mistake or not a mistake, the impact remains with the family, that when those true findings are made, the children and the families are separated, and that impact lasts forever, whether they were right or wrong. And if half of those, almost half of the findings were overturned, the reason for them being overturned really is irrelevant to the impact on the family. Would you agree with that?
I agree. That was exactly my first point, was that it's causing harm whether they intend to or not. I don't think that anybody in DHS or the Arkansas State Police is an evil person and that they intend to come in and trample on civil rights in order to protect children. I think that they all believe they're doing the right thing and an honorable thing in protecting children. The problem is we've let them write all the rules, and they've got a very efficient system. It's so efficient.
That's fine. I think you've explained that, and I appreciate it. Thank you, Mr. Chair.
I've got one more, and let me say, as a chair, I will try to keep the meeting on track, but I have a deep belief that those of you that were elected to represent the people of Arkansas ought to be able to ask your questions if at all possible. So Representative Tucker.
Thank you, Mr. Chair. Just a real quick question. I think it's important to clarify. Do you know what percentage of the true findings were appealed?
I do. I can't put my finger on it right now. I'm sure somebody up here could. I've got the documentation here.
Now would be a good time. I've got some reports that were asked for in our last meeting by members of this committee, and they were given to me, but not to Karen, and so we got them printed out today during the meeting, and so it'll have those numbers by county for at least 2014. I think it has 2015 also.
Great. Thank you. Thank you, Mr.
May-
Churchwell.
That
Yes,
brings
sir.
another question. May I respond to that, Mr. Chair?
Okay?
Or another short statement. By statute, the notification of a true finding has one sentence that says you have a right to an attorney. If you cannot afford one, call legal aid. Okay? So I called legal aid, or actually the Bureau of Legislative Research helped too, and Senator Clark also procured some of this stuff. I asked for 3 years the numbers of people that had a true finding that called either Center for Arkansas Legal Services or Legal Aid of Arkansas. I asked for the numbers of people that called and then the number of parents that they had actually represented in those cases. And it was about 148. Jean Turner Carter is the executive director of Center for Arkansas Legal Services. She said between January 1st, 2012 and June 30th of 2015, it's 3.5 years, 193 applicants contacted our program regarding child maltreatment central registry issues. To cut to the chase, 28 were represented in administrative hearings. So in 3 years, 28 families were represented by the Center for Arkansas Legal Services. Legal Aid of Arkansas had 145 potential clients, 115 cases being closed as counsel and advice. In other words, they took the phone call, they talked to them, they closed them. 4 had limited action, 15 some form of extended representation. And when you look to the chart, that does not necessarily mean that they were represented at a hearing. In fact, administrative agency decisions were 10. So that means they went to 10 administrative hearings out of 145 potential clients. So that's 38 people in 3 years on child maltreatment registry that actually called because of that one sentence and got help. There's no contract with the state for legal aid or the Center for Legal Services to provide these services. It's on a come-as-you-come basis. I don't think that a lot of okay, here's my opinion. You asked how many were appealed overall. I think the great number of these are not appealed for 2 reasons. I think a lot of the people are not sophisticated enough to read that and understand that they have a right to call and get an attorney or to appeal. 2, that being on this child maltreatment registry has no impact on them whatsoever. And there are people that it just doesn't matter if they're on the maltreatment registry. Why should they take the time or spend the money to appeal it? So a lot of these, I think, would be erroneous. I think if you went through every single one of them and required an appeal, I think over 50% would be overturned, and that's just my opinion. But I would be interested in seeing that.
Representative Tucker?
That's it for me. Thank you very much, Mr.
All right.
Chair.
Thank you. Now I get my mic on. Mine's a lot simpler. Mr. Churchwell, thank you for being here, and I'm sorry I do not recall your name.
My name is Brian Welch. I'm the director of the Parent Council Program.
Mr. Welch, I'm sure that you have some information that this committee would like to hear, but we have some other people that were already on the agenda.
I understand. I had no intention of speaking
Sure.
today, so.
Okay, but we may want to call on you at a later time.
Anytime, I would be happy to come and speak to the committee.
All right, thank you for being here. Chair would like to call Thomas Braswell.
Would you like me to stand aside, Your Honor?
I'm sorry?
Would you like me to stand aside?
Please, yes. It's an attorney, Representative Hickerson. She moved it. Okay, Mr. Braswell, would you state your name, employer, and position?
My name is Thomas Braswell. My employer is the State of Arkansas Department of Human Services and Families. I am currently the assessment unit supervisor for Clark County.
Okay. Would you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Braswell, you are here today at my request. Is there anything that you would like to present to us? Okay, I just wanted to be sure that you had an opportunity. Mr. Braswell, how long have you been working in the position that you're in? Would you turn your mic on, please?
A little over 3 years.
Okay. And what is your position again?
I'm the assessment unit supervisor for Garland County. I supervise the investigations.
Okay. And what other experience do you have along the lines of these investigations?
I'm a returning state employee. So I've worked as an investigator in Garland County doing child abuse investigations. I've worked at the Garland County Juvenile Court as a juvenile probation officer. I had various responsibilities there during my time there. I've worked in parole in Texas, a sheriff's deputy in Louisiana, worked with East Texas CASA, court-appointed special advocates as a volunteer advocate. I worked in a youth shelter. Also worked in a plumbing warehouse for a short period of time when I moved to Arkansas trying to find employment.
Okay. Do you have any idea how I first, why I first contacted you?
I believe it was due to some issues with child removals in our county.
It was. I contacted you for the first time in May, and the reason that I contacted you is that I had been dealing with a specific case, and after several months had come to some conclusions on my own with the information that I had, and had been told that that if I knew everything that that everyone else knew, that I would have come to a different conclusion. And so that's when I started talking to people that I hoped would know. And we had hoped that Heather Finley and Cecilia Dyer could be here today, and they're not, and we appreciate you coming instead. So I have some questions, and some other folks have some questions. I'll get the ball rolling. Tell me about the relationship between the entities, CACD and DCFS. Do they do things the same way? How are do they have to meet the same guidelines, or do they do investigations differently?
I've not done any investigations for the state police. I don't know what they are told they have to and not have to do in the course of their investigations. I can say that the relationship in our county is that if the state police is investigating a call and they have a safety concern, they contact us and we go out and assess the safety of the children. And as far as reviewing their work, the only time I review any state police investigations is once they're completed. They come electronically to our county inbox. I review those investigations that have been found true, and I make the decision to open up a protective services case on the children or child, depending on how many families are involved, and assign those out.
How long does DCFS have to complete an investigation, if y'all are doing the investigation?
We have 30 days. The law's extended it to 45, and we can request an extension.
Can request an extension up to 45 days. Do you ever get recently closed investigations in the work you do at DCFS from CACD that were opened at a time that was much longer than the 45 days?
I didn't hear your question. I was focused on not misleading you. We can request a 15-day extension at the end of the 45 days.
Okay,
we
so you
can't-
can actually go 60.
Yes, sir.
Okay. Do you ever receive, in the work that you do at DCFS, ever receive recently closed investigations from CACD that were longer than the 60 days from the time they were opened?
I'm not certain. That's the answer.
Okay. We'll reserve that question for a future time from another witness. Is DCFS required to interview the alleged adult offender?
We do, yes, sir.
Okay. Does CACD always do that?
We don't always do it either, but they don't either.
Okay.
There are cases where the offender will, you either can't locate them or they've refused an interview. And there's a process that we go through on that.
So it's required for both, but sometimes neither of you do it?
There are times that the offenders are not interviewed, yes, sir.
Okay. Representative Fott.
Thank you, Mr. Chair. Could you help me with a little bit of history here? How long has it been the case that there is the division with two entities both doing investigations? Has that always been the case, or how long ago did it come about that DCF sometimes does the investigation and then the Crimes Against Children Division sometimes does it?
I started the first time with the state, I believe it was in 97 or 98, and it was like that when I came on. So I don't know when it actually started.
Okay,
But we've had both entities since, both times that I've been an employee, so since the late 90s, I know it was in place.
Okay, was there ever a time when DCFS did all the investigations that Crimes Against Children now does, to your knowledge?
I do not know. I wasn't here at the time.
Mr. Chair, maybe later someone can answer those for me.
We will definitely get someone at a later date that can answer those questions.
Okay, thank you.
Senator Rice.
Thank you, Mr. Chair. The last meeting that we had this subject, there was testimony that, and I welcome some help if I'm not being clear, but an investigator that interviewed one side, let's say, and then maybe the person that the call went in on might be in a different county or a different location. They were they were questioned by a employee of the state. And my reason for citing that is you have an accusation against a person that can change their whole life, take away their livelihood, and yet they've not had the common sense, I call it, right to answer questions from the same person that investigated the other side. What do you do in those instances? Do you make sure you talk to both parties, or is it sometimes handed off to another agency person to check another side?
Whenever we receive an investigation where, for example, we have the one half of the family is living in Garland and the other half is living in Faulkner County, what we would do is send a secondary request to that county and have an investigator in that county go assess that home and talk to whoever needs to be talked to and interviewed in that home. So we would not personally interview those folks ourselves. We would ask another investigator from whatever county they lived in to do those interviews for us.
Do you feel like that is a questionable practice when, let me ask you this, would you want to be in that situation and not get to talk to the person that was making the accusations, or that at least as investigation, that you have the accusations, would you want to talk to that person? Or
You're
just
referencing the primary investigator? That, like if,
I'm talking about there's been accusations made to you, and you're handing it off on the party that's been accused for somebody, let's say a third party, fourth party, to go out and try to gather information. Would you want to be in that predicament of not being able to hear you and I and everybody else size people up when we talk to them. We look at their body language, we listen to the tone of voice. There are a lot of things we do sizing people up. And the one thing I got out of that last meeting that I made the statement, I'm not mad at some of the state employees. I'm mad at the process, because there's not a fair process. And I'm asking you, would you want, if you were in that situation of being the accused, would you not want the opportunity to talk with the person that has the power to cause you lifelong trouble? Would you not want that opportunity to talk to them directly?
I would.
I would too. Thank you, Mr. Chair.
Representative Gates.
Thank you, Mr. Chair. Mr. Braswell, I think part of our trying to figure out a process, a lot of us have concluded we think our process has some flaws in it, trying to fix those flaws without creating bigger flaws and bigger traps that children could fall through the system is the difficulty here is trying to do that. One of the things that I see is a conflict is in giving so many different entities the power to take children that are all equal in their ability and their authority to take children can bring conflict, because oftentimes at the scene we have multi-jurisdictions at the scene. For instance, at a death scene, you may have a state trooper, you may have a city police, you may have county, and you may have a coroner. And I believe the coroner trumps them all at a death scene because that's his jurisdiction. At a fireman may trump everyone else. And I guess my question is, at a scene where you've got multiple entities, DHS, any kids that are taken are ultimately going to end up in DHS custody. Is there any trump? Does any one agency have a trump over the other one when it comes to taking kids out of the home?
I don't believe so.
So if y'all are at the same scene as 6 other agencies, I think there's 6 different agencies, county, city, state, state police. If they're all at the scene, all of them could rule one way, and if one of them decides you're all wrong, they could actually take the kids.
They would take the whole and give the children to the Department of Human Services. Yes,
And then
sir.
y'all would have to defend their actions, although y'all may have disagreed with their actions at the scene.
That would be a legal question. I don't know that we would physically have to defend it.
I think y'all attorneys have to actually go before the judge to ask for the hold.
I'm not sure that I'm not a legal person, so I know that if the state police were to take a hold, or not the state police, but
Let me ask.
I guess if law enforcement did, I'm assuming
y'all
that,
have to defend that.
we would be defending them, yes, sir, but that's
In
just
your
an
investigators that are in y'all's department, would you say that all of the people that we've authorized to take kids out of the home all have the same level of training?
All of the people with Division of Children and Family Services?
No. Every entity that we have given the authority to remove children from the home, do they all have the same level of training?
you're getting.
I'm not trying to trick you. Do you
You're
think your
getting into my-
investigator has a little more experience and training on whether or not to know whether those children are in jeopardy, immediate harm's way, versus a officer who just came out of cadet school and just got certified to run the beat in his town?
Being that I have been to a basic law enforcement academy and I have been to the new worker training with DCFS, I can tell you the training is not the same. No, sir.
Okay. All right. Thank you.
Senator Cooper.
Thank you, Mr. Chair. I guess this one is for the chair. This report that we received a little while ago, is there a legend that goes with this? Who prepared this? There's some questions that I have on here that I don't understand
Okay,
how this was derived.
We handed it out because of Representative Tucker's question, and there were answers there. It was given to me by Cecile Blucher, and I don't know if it was she or someone within our agency that prepared it, and I wasn't going to hand it out until we got to that point.
Okay, specifically, I'd like to know how these percentages are derived and what they're derived from. For instance, in the last column, it says percent of all investigations overturned. If it's not a true finding, what is there to overturn? Where does those percentages come from?
Okay. Can we reserve that question
Sure.
until we have?
Yeah, thank you.
All right. Representative Payton. Well,
Test. Oh, we got
there
it.
you go.
Thank you, sir. Thank you, Mr. Chair. And I really just wanted to follow up on my question before, and I'm not qualified to answer Senator Cooper's question, but I got an answer to my question. I think it's beneficial for the members to have this. I spoke with Representative Sullivan, who raised the issue. And in any event, 16% of the true findings are appealed. And so that's the answer to that question. And of those 16%, 45% of those are overturned. That there may be a reason that 84% of the true findings go unchallenged that Mr. Churchwell was elaborating about. And I'm not going to speculate on that, but I just think it's helpful to understand that 45% of the ones that are actually appealed are overturned, and that's actually 7% of the overall number of true findings, not 45% of the whole. Only 45% of the appeals, and that's 7% of the whole. So I just wanted to offer that clarification for the benefit of the members.
Thank you. The chair has offered that clarification at a couple other meetings, but thank you.
Thank you.
We do need to remember that. Representative Fott.
Thank you, Mr. Chair. Recently, in our other committee that I serve in, the Aging Children Youth Committee, DCFS has talked quite a bit about differential response. And I'm wondering if you know if the Crimes Against Children Division has something similar that they use when there is something that does not rise to the level of actual abuse, but that they were called into the home, and then perhaps they determined that this would be more appropriate for something like differential response. Is there something similar?
To my knowledge, no. However, I do receive calls from the CACD asking me for assistance with families that don't necessarily rise to the level of a safety assessment. And in those cases, we do go out and talk to the families if there's something that we can do.
Follow up, please.
Yes, go ahead.
Could you give me an example of that, or how you would follow up with that? Do they then turn that over to DCFS, or do they have you follow up? I mean, do they have Crimes Against Children Division follow up themselves, or do they turn that over at that point to DCFS?
Well, to my knowledge, it's turned over when the request is made to me.
Okay.
Generally, it's orally, and then I receive an email follow-up. The most recent example that I can come up with is generally a gentleman that they didn't believe had a baby bed. And we were able to determine that he did have a safe place for the child to sleep. The place actually traveled with the guy, or with the baby, from his house to the babysitter's house and then back at the end of the evening or whenever. But that would be a typical non-safety response request, where we would go in and see if there's something that we could provide to a family.
Thank you.
Yes, ma'am. Representative Tosh.
Thank you, Mr. Chair. Mr. Braswell, there's been a lot of talk, questions today, and I just need some clarification talking about the accountability and responsibility of these investigations and who takes control of these investigations and at what point. Just so I'll understand, once law enforcement removes a child from a home, can DCFS override that decision and place that child back in the home?
I believe that would be more of a question for my higher-ups or legal. I
That's
guess
fine.
My
yeah.
answer would be I'm not certain that I could override that. I mean, it seems to me that we could place a child back in the home, but if a 72-hour hold was taken, it would have to be released, and I'm not sure who would make that decision. It wouldn't be me.
If you don't know, that's fine, and maybe that is a question we need to get answered. But I just want to make sure everybody understands that at some point, it's basically, if the answer to that is no, then basically at some point, you don't have the authority to override the law enforcement's decision. There's been a lot of questions about the certification of law enforcement, how much experience they've got. That really is not anything that you can control once that officer's removed that child from the house. Is that correct?
That is correct. My procedure would be to contact my supervisors and let them know what's going on, and the answer would have to come from higher than me, because I wouldn't override.
Okay, and with that said, then, we'll find the answer to my question. Once that decision's been made by law enforcement, you, sir, the question I want to know, do you have the authority to override that law enforcement's decision and place that child back in the home? And I just, from there, we can move forward with the answer to that question.
Me personally, I do not believe so, sir.
Well, let's get a definite, okay? Thank you, Mr. Braswell.
Yes, sir.
And Representative Tosh, I hope you will bring that question back up when we have the superiors here. Mr. Braswell, do CACD employees ever complain about you to your supervisor?
I'm going to be careful in the way I answer it. I believe they complain about my work, yes, sir. Not me personally.
Do you know what about specifically?
Frequently not happy with the safety assessment or the safety determinations that I make. And I've also been accused of perjuring myself in court.
Okay, well, let's go with the safety assessments first. What is it in particular they are not happy with about your safety assessments?
Frequently it would be not removing a child or children from a home. That's generally what it would involve.
So you make that decision?
Yes, sir.
Generally, Generally, the decision's with DCFS and it's with the supervisor.
It's with the supervisor. If I'm the on-call supervisor, or during the day when I'm at work, I'm the person that has that decision, and I contact my supervisor and let her know what's going on. So it's not just Tom making the decision overall, but I am ultimately, in my opinion, responsible. Yes,
Okay,
sir.
well, that's helpful with a lot of questions we've had in the past few months, is that normally it's a DCFS supervisor working with their supervisor that makes that call, okay? And so that generally then CACD is not removing children, but asking you or whoever is in your position to make a safety assessment and to remove that child or children. That's normally the way it works. If I'm wrong, just tell me where I'm wrong.
Yes, sir. The process is if they have a safety concern, they contact us. Normally it's via phone and then an email. and then I assign a worker to go out and assess the safety of the home, the children. And once we get that safety request, we have one of two options. We have the option of putting in a protection plan if we can safely keep the children in the home or safely somewhere else with the non-offending parent, or make the situation safe, or we can remove the child. We only have two options once we get the request for the safety assessment.
So, since there have been more than one complaint to your supervisor, specifically about not removing kids from a home, children from a home, then I would say it's safe to say that CACD often wants children removed from a home when you feel it's not warranted.
Is that a yes or no question, or can I?
It's a yes or no, and then you can elaborate.
I would say that I don't know that they particularly want the children removed, but I can say that they disagree with my decision to either leave the children in the home or do something else besides remove the children. I mean,
Okay.
they don't come. I've not had somebody come out and say, "Tom, you have to take these kids." That is not happening.
Well, no, that wasn't what, but if they disagree with your decision not to remove the children strongly enough to go to your supervisor, then they believed that the children should be removed.
I don't know that I can answer to what they believe. I can tell you that they don't agree with.
Well, they were unhappy with you.
The times there have been disagreements, it's because I did not remove the children.
So, okay, I think that answers it. So it's safe to say they were unhappy when you made that decision.
In the times that there have been complaints, yes, sir.
In the times when there have been complaints to your supervisor, it was because you didn't remove the children. You didn't make the decision to remove.
That is
You
correct.
decided to do something else.
I've not had a single complaint when I've removed a child.
Okay. Has this been going on for a while?
Since I've returned to Garland County, yes, sir, for the
So-
last couple of years.
Okay, so not just yesterday. Okay. To your knowledge, have children been harmed because you refused to remove them from a home?
To my knowledge, no.
Okay.
Now, I can expound. I've
Sure.
had protection plans
Please.
that I've put into place where they have failed later on, when we're monitoring a protection plan that we put in place, and it's failed, and we had to ultimately remove the children. There's only been a couple of those to my knowledge, but directly, I'm not aware of any child that's been harmed after I put a protection plan in place. No, sir.
Okay. Have you ever sent someone that you're supervising to a CACD investigation to see about implementing safety measures, and it was made plain by CACD and or law enforcement that they were not welcome?
Can you restate the question for me one more time?
Have you ever, and counsel, I'm not asking about a specific case, have you ever sent a DCFS employee that you supervise to a CACD investigation with the purpose of seeing if a safety measure could be implemented rather than children taken, and they made it plain that DCFS was not welcome?
No, sir.
Okay. Does that sound even similar to things that have happened?
Sir, I believe that would be getting more case-specific and.
No, I'm not getting case-specific. I'm asking, don't give a rat's rear end about a specific case. What I want to know is, have you sent, because we already know that there's a disagreement, from your testimony anyway, about when kids should be removed and when they shouldn't be removed. And so now I'm asking, okay, is there have you had an experience or experiences, okay, where you sent someone, And let me change the wording, where you sent folks to, for a safety, to see if a safety plan could be done, and were informed that they planned on taking the children.
Can you repeat just the last portion of your question, probably the last 10 words?
Maybe the council can tell me what part of that needs to be repeated.
If you could just restate the question, please, and I will try to answer.
Okay. I'm going to start from the beginning. Have you ever sent an employee under your supervision, which means they would be working for DCFS, to an investigation where CACD is, okay, part of the investigation, with the purpose of seeing if safety measures could be implemented rather than children taken out of the home, and that effort was rejected, and you or your employee told that they were going to take the children?
Senator Clark, if I could, Mr. Chair, the way you originally asked that, or at least modified it a few moments ago, you said, has there ever been an experience or experiences where that has taken place? And if that's the modification, I think it'd be okay for me to answer that.
Well, if you had not advised him to have me reword the question, I'm glad that you remember it well. We would have went ahead and answered it the first time. So go ahead, Mr. Bradwell.
He didn't ask me to have you restate the question. After I talked with him, I couldn't remember your question, so I'm sorry. Yes.
The answer, let me say again, so make sure that I got the answer. The answer to my question was what?
If you're asking me that I have sent one of my employees to do a safety assessment generally of a home, and that somebody disagreed with me or disagreed with our efforts and a different decision was made that I didn't make, has that happened to me previously? The answer is yes.
All right. Thank you. I think that answer will suffice. I could ask another question to make the counselor jump, but I will go to Representative Fite.
Thank you, Mr. Chair. There are several of us who are new on this committee, so would you please explain to us what CRIS is, what that stands for, and how it is used by both DCFS and by the Crimes Against Children Division?
The Children's Reporting Information System.
Yes.
CRIS stands for. It's a database that's not connected to any outside source, such as food stamps, Medicaid, NCIC, law enforcement, anything like that. And it's where we document all of our investigative and casework activities, whether it be a CACD investigation or one of ours.
And may I have a follow-up?
Yes, you can.
Yes.
Mr. May.
Does DCFS document that you look up something in CRIS history? Does that register immediately or not?
Are you asking me, can they tell if I looked at something?
Well, I was just wondering if you, as a matter of routine, document when you look in CRIS.
If in the course of the investigation, one of the things that we do is a CRIS history check. We look to see what calls have been made, what they were in reference to, and how those calls were founded, true or not, and also the case history. And we do document that when we do that. Yes, ma'am.
Okay, and does this give you a clear picture of the past involvement with this family that you have had and that Crimes Against Children Division has also had?
It's not always clear, but it does give us, how many calls have been made, and if there have been true findings in the past, and if there have been casework activities. But You could have somebody with lots of calls and no true findings, and you might find where there's a cluster of, take for instance, environmental neglect. And then when you look all that up, you can go into the specific investigation and you can look, and the investigator documented what was there when they went. And the folks may have cleaned it up. It could have been dog urine and feces covering the floor, and something else was done other than take the children. The home was cleaned up within 24 or 48 hours. And at that point in time, the investigator didn't think it was serious enough for a true finding. But if you see a pattern of that where you've got, 8 or 9 calls or however many in a row, it might be an indicator that this family is not learning or may need further services, or ultimately a true finding. Because, if they've got 20 dogs, or let's say 13 cats, let's use a real world example, 13 cats living in a 21-foot travel trailer, and you only see 2, and there's 13 of them in there. It's pretty bad stuff. But you get a picture, and I can't say that it's always clear to answer your question.
Okay, thank you.
Representative Gates.
Thank you, Mr. Chair. Last time we were here, we heard people that we had a state employee that had been accused. I think they had a custody hearing or a divorce hearing. I think it's custody hearing that seems to have sparked the phone call to the hotline. He lost his job for the state because his supervisor chose not to allow him the appeals process that we afford most everybody. The state seems to be very determined to never use the word guilty, and I think most of us on this side of the table find it absolutely ludicrous to not use the word guilty when we've put them on a registry that we then fired them over. And we recognize that there's an appeal process, but we've also penalized them already simply because an investigator has found them guilty. In cases where I was thinking about the CRIS program, have we ever found a case where every time a custody comes up every year or two, and one parent is challenging trying to get custody, that they make an accusation, it's found false over and over again? Have we ever used the evidence from all the other cases where we have found it to be false, knowingly false, all from the same person? Have we ever, DHS, ever done anything about that process?
I can't answer for DHS. I can tell you what I have done in Garland County since I've been back.
Please.
I have, whenever I have somebody that either has a complaint of harassment by hotline is what I call it, or I see a pattern of harassment, I turn that information over to Joseph Graham of the Garland County Prosecuting Attorney's Office for him to look into. I don't know if they follow up on them or not, but I've turned in 7 in the last 12 or 13 months.
Okay, let me ask you a question. We had an incident in Garland County. A sexually oriented business had opened up illegally in the county. They sent in undercover investigators in. They found that it was true. They got a search warrant. That search warrant was executed. The county confiscated 10,000 videos or so, whatever it was, 1,000. I don't know what it was. It's a large number. That warrant failed to say that because a possible violation of your civil rights of free speech, which the Supreme Court has ruled that some of those fall under the free speech, that because it could potentially violate free speech, their constitutional rights, that they had a right to a 72-hour hearing, and we failed to give them that window to appeal simply because it was a constitutional rights issue. I know that we have a time frame at which we have to investigate to ask a judge when we've taken kids to be able to continue to hold those kids. and we keep talking about, for the sake of, you know, if we're going to err, let's err on the side of caution. Is there anything in that process where we're looking at constitutional rights that may have been violated if we're wrong, and if we have investigators that continually make that habit pattern of making their own decisions? Would we not say that the state is now perpetuating the problem because we've allowed our investigating system not to be corrected? Is that too convoluted question?
You know, I'm not a legal person.
I understand.
So
Asking your
you're
opinion.
asking my opinion.
I consider you a professional. You do this every day and you get paid for it. I consider you a professional.
Can you shorten it up a little bit?
I can.
'Cause that question was
I can.
huge for me to wrap
I
my
know,
mind
it
around.
had, it was a compounded question. My attorney would have kicked me underneath the table. Understanding people's constitutional rights and not wanting to violate or infringe adults or children's constitutional rights. Is there anywhere in the system that their constitutional rights of speedy trial, for instance, I know Mr. Churchwell's guy has lost his job and still waiting for an appeal and waiting, and still, from what understanding, still, as our last one, still is waiting and still can't get a job because the state has drug his feet. And if found innocent, he has no recourse because we owe him nothing, although we were wrong and we put him on a registry. Is there anything on the system that goes towards ensuring those civil liberties of people in taking of those kids?
Other than personally, I think it goes to a well-trained staff and supervision. And I think that would, you know, you're getting to whether, you know, we're infringing on somebody's rights with this true finding, and then the time it takes to appeal. I do all the appeals for Garland County for children and family. And, you know, when they get served that green card, they've got 30 days to appeal. People frequently call me. I've had people from our investigations come in and talk to me where we found sure on them, and I've helped them write the letter to appeal. And I've not seen what Mr. Churchwell has seen. I have no idea what the time frames are people are waiting. But in my experience, they're pretty speedy. And I've sat there and had people win their appeals all by themselves without an attorney, because the state, me, or whoever, if they don't have an attorney, has to prove the case. I had one lady sit there and not say a word and won her appeal. Wasn't mine, mind you, it was from another county that I was representing. But they won their appeal just by not saying a word, because the state still has to prove that true finding. Are there bad people? Yes, sir. But again, with training the right people and supervision, I think it's the best way I can answer it. I think that's the only, other than that, I don't know what protection there would be.
Let me ask you this one last question. If you're a parent and your kids have been taken out of your home, and they're taken out and they're continually out of your home, you have very little time to see the kids that haven't ever been out of your home. We were very protective of parents. We just didn't let our kids go anywhere. We were protective. If those kids were out of your home for 60, 90 days, would you not agree that parents become very desperate trying to grasp straws because their life is turned upside down, that in trying to get their kids back, that they may not have the clarity of thought to be able to defend themselves, or how to go, simply because of the trauma that has been created, if it's unjustifiable? Would you not say that's a pretty traumatic experience if the state comes into your house and takes your kids and you did nothing wrong?
Yes, sir, it would be.
Thank you. Thank you, Mr. Chair.
Mr. Braswell, you mentioned earlier when you had complaints to your supervisor about you. One was not taking children when CACD thought they should be. And the other, you said, was perjury?
Yes, sir.
So you've been accused of perjury by CACD?
I have.
Okay. And now, the next question I'm going to ask you, I think is the only question that I got permission from you to ask. Because I like to be transparent. But I didn't want to ask you this question and get you in trouble. Have you ever committed perjury?
I have not.
I just want to, everybody wants to paint the picture that we're holding hands and singing Kumbaya with CACD and DCFS, and we agree on everything. I want to make it clear that we don't. Counsel, you can tell us whether we can answer this next question or not. Can you tell me, have you been accused of perjury by CACD more than once?
No.
Can you tell me when? That's okay.
No, sir. I cannot.
Okay, no problem. Had to ask a question, though. I don't know how you're going to ask this question, because this question was actually for someone else, and we've asked people to be here so many times. We try, when they can't be, we try to be understanding. Have you ever seen a lack of documentation of evidence by CACD to support true findings?
As I review investigations from the state police
Yes.
that are found true to open a case,
Yes.
I myself am not looking for the preponderance of evidence. I'm looking at what they're saying was found to be true and who I need to open up the case for. I have seen lack of documentation. But to be more specific, not the same level that we did
So,
in DCFS.
and that's a fair answer. So that in reviewing for what you do, there were cases where you did not see the same level of documentation, at least, that you at DCFS and Garland County would have wanted to see.
That I require of my workers, and the policy says that we do, yes, sir.
Okay, thank you. And again, these questions were for somebody else, so would be interesting to get your answers. Does CACD fail to share information on ongoing investigations with DCFS? Ever?
Once we get the initial request for a safety assessment, we generally get the phone call and then the email follow-up with the concerns. We do talk to the investigator if we do have questions, but we do not, and have been told not to, we don't interfere with their investigation. There's only 2 places that we actually document in their investigation, in Chris, which are specific to us. And I just lost my train of thought.
Okay, well, I'll follow up on that, but I'm going to go to Senator Cooper.
Thank you, Mr. Chair. You referred a while ago to a plan, and what did you call that, a safety plan or a family plan or something to that effect?
Protection plan.
Protection plan, okay. Explain to me basically what that amounts to. Is that, if we're talking about the same thing, what I have in regard to is once an investigation is done, a true finding is in place, and there might be some plan formulated on some documents that the family might need to do certain things to regain custody or whatever. Is that what you're referring to?
No, sir. You're referring to a case plan.
Case plan, okay. On the case plan, The information that's put in that, I'm talking about on the top of the form. You're familiar with the form, right?
Vaguely, because I don't do, I'm not the casework person. I do the
But you've seen them, right?
Yes, sir, I've seen them.
Okay. I'm talking about at the top of the form. Where is that information populated from? Is that information long-handed in there and typed in, or is that canned information that somebody pushed a button on a computer and got populated? In other words, was that a menu that was selected and somebody pushed a button and populated a field? Or was that something that somebody wrote in based upon what they saw and what they needed to go in that field?
Our case plans are specific to the families. There are some court-ordered services that the court does if it's a court-involved case. If it's not, we have what FAST or CANS. It's a needs assessment for the family that the worker actually. It's an interactive tool that we use, and we discuss it with the family, and that's where that information comes from. Is from the family. So the case plan should be information from not just the caseworker, but from the family, and it's a plan that they help come up with.
That case plan requires a signature at the bottom. And what they sign to, they're signing a legal document, right?
It's a document, and
Right.
it's part of the case plan, yes, sir.
So what they're going to do is there's follow-ups that are going to be done on that, like there's going to be visits, and they're going to talk about what they've done, and there's also requirements there possibly about things that they have to fulfill based on that plan.
Generally, yes.
Okay. Now, suppose that they did not provide that information that's on there, and they disagree with that information. In fact, they view it to be false. What's their recourse?
Their recourse would be to have a staff meeting with the worker and the supervisor, and possibly even the supervisor above them. If they're represented legally, then the attorneys would be invited and all that. But, I mean, it would be something that they would work out in what we call a staff meeting. If it's a court-ordered service they don't agree with, and if it's court-involved, then it would have to be changed in court.
If they disagreed with it, and they didn't make the statements that appeared there, where did it come from? The investigator put it in there?
No, sir. The investigator doesn't do the case plan.
Okay, if it wasn't the investigator that put it in there, and the family didn't put it there, how'd it get there?
It would have to be the person that typed that case plan. It would be the worker. That's who types it in.
And what would they be basing that on?
Not having we can't talk specifics. I don't have a specific example. I don't know. I have no idea. I can only tell you what I've been trained to do and what, how a case plan is developed. And if there's some erroneous information in there, I have no idea.
Okay. Thank you, Mr. Chair.
Thank you. Mr. Braswell, does lack of CACD sharing information, if that were the case, ever cause problems for DCFS in being able to properly assess the ongoing safety for children to be able to return to the family home?
I would say, in my experience, the cases that I've had contact with, I would say no.
Okay. Do you, DCFS, CACD is seen as, and I'm assuming properly so, seen as a contractor?
I believe they are. But that would, again, be a legal question for somebody up higher than me. But they do, they do a service for children. They do a service for children and family, yes.
Do you think anyone that does investigations like DCFS does, should be held to the same standards as DCFS?
I do.
Do you think CACD is held to the same standards as DCFS?
Based on the very limited review of of the investigations that I see, no.
Okay. Does DCFS require a supervisor to approve all interviews before closing an open investigation?
We do.
Is it your belief that CACD always does that?
They do not.
Okay. Have you ever heard anyone in CACD say that they might find a true finding whether they had the evidence or not, and just let the family appeal it?
I have.
If I asked you for a name, could you give me the name of that person?
Yes, sir, I could.
Okay. I may recall you at a future date to give us that name, but for today, we're going to continue to play nice. Okay. Any other questions for Mr. Braswell? I still have a few. Representative Payton.
Thank you, Mr. Chair, and thank you for taking my question. Mr. Braswell, I'm not a member of this committee, and I've missed some of the testimony, so if this is repetitive, please excuse it. It'll definitely be elementary. Working off the assumption that not all takings are justified and that we do make mistakes, can you give me what percentage or an idea of how often we have taken children and then found out that it was a mistake? And with that, can you give me a time frame on how long it takes to admit the mistake and return the children, and whether or not there are repercussions for the employees that made the mistake?
And we're talking my personal experience? Because that's
as
all I
much
can base-
information
that's
as
all
you
I
would
can base
have,
it
yes.
on. My office, I mean, I can only speak to what I do. I mean, I don't know if you're wanting me to speak broader than that. I mean, we have taken 72-hour hold on children where there has been an emergency, that we've been able to work something out, sometimes within hours. Can't talk specifics, but I'll give you an example if you'd like to hear it.
I would like to hear it. Thank you.
Okay, we're out doing a safety assessment. The allegations are the child's home alone at night and the environment's horrendous and there's no running water. We go out in the evening and the guy refuses access to the home. One of the things that I've heard talked about here. He said no. My investigator is there and he says, what do? I said, let me talk to the guy. I talked to the guy for about 10 minutes and I tell him, look, if you let us in the home, let us see what's in there, I can work with that. Well, can you tell me you won't remove my child? No, I can't tell you that. I can tell you that we can work with that, and if there's something that we can make safe, fine. But if it's not, we might have to do something else. The guy says absolutely not. He won't let us in the house. We call the cops. He decides to let us in the house because it takes the police about, and you know, a lot of folks probably think the police go out with us, but that's not necessarily true. I don't know how it is with the CACD, but generally we're alone. So it takes them about 20 minutes to show up, and before they show up, the guy decides to let us in. So my investigator goes in, does a drug screen on the guy, and the house is horrendous. We're going to have to do something else. We haven't decided what yet, because we haven't discussed what he's willing and able to do to make this safe. Could he go somewhere else? Does he have a relative or a friend that he could stay with? If he cleans this up, does he have some family support, things like that? While my investigator's talking to him, the guy runs out the door into the woods. The sheriff's department finally shows up. They look for him. They can't find him. The next morning, we find the child at school. And we had made a decision we were going to pick that child up based on 3 of the 14 factors, 15 if you count others. But we had identified 3 safety factors, one of which the guy's not going to cooperate and going to flee. Generally, we were able to talk to the guy, find out that he did have family, and we worked something else out besides foster care, and the child is safe with family today. I'm not saying we do that in all cases, but your question is, have we made mistakes? I make mistakes every day, but it's not because I'm running from my job or not trying to do it or getting mad at somebody and taking their child because I'm mad at them.
Okay, if I could follow up, Mr. Chair.
Please.
In your experience, do you know of any cases where the state took children from a family later to find out that the evidence and the accusations did not substantiate a reasonable taking or a justified taking?
I would say I have no personal knowledge of that.
So as far as you know, we have a perfect record.
I'm not saying we have a perfect record.
Well, if you don't know the case, then I can't ask the rest of my questions as far as how long it takes us to admit we're wrong and is there any repercussions for being wrong, because you don't know of any instance where we were wrong.
If I might,
If we're getting into a case-specific situation,
I have no knowledge
I didn't
of the cases.
I didn't review it, so I don't know.
No, it's not case specific. I'm wondering if there is latitude within the agency rules for employees to admit that they're wrong and return the children within a certain time frame. Do we give them latitude, or do they just have to defend their actions for infinity because they can't admit they're wrong when they've taken children?
I can't answer your question. I have had a worker take a 72-hour hold on a child.
just speaking to the mic.
I have had a worker in my office take a 72-hour hold on a child, and we've had to apologize within 2 hours and explain what the reasoning was. And it was a worker error, because I guess I can't get into case specifics, but let's say, for example, a child has Mongolian spots, and if a worker has never seen Mongolian spots, or if a daycare or a school's never seen them, a lot of times they can be mistaken for severe bruising. So, I mean, we have made mistakes and actually had to apologize and call parents and give them their child and try to make it better.
So that's one
personally,
case
my
you know
office-
of, and it was very quick, 2 hours. Were there any repercussions or anything for that employee?
We did a training in the office on specifically Mongolian spots. The worker wasn't disciplined at all. I mean, the professionals in the community, other than the primary doctor, thought the child had been severely beaten. And then whenever we had contacted the primary doctor, because when we got the child to the office and I examined the child, I mean, we called the doctor and cleared it all up. But people make mistakes, but a one-time mistake, you know, if that employee would have shown a propensity for doing, you know, picking up children for no reason or something like that, I mean, there might have been a reason for discipline, but it wasn't a moment for education. And I'm recalling the situation. It was back in, I think, 1998. Oh, I can't talk about specifics. Generally speaking, I mean, it's been. Generally
Thank you for
speaking,
your
it's
answer.
been a long time ago for this. We're looking for an example. I mean, it's been a long time.
So we either believe we have a near perfect track record, or we're very poor at admitting our mistakes, one of the two.
Depends on your perspective.
Thank you, Mr. Chair.
If I could follow up on that, Mr. Braswell, used an employee who had, if they had had a propensity for taking children, that there might have been discipline. Have you ever had that problem?
I have not personally, no, sir.
Okay. How do you personally feel about anonymous calls to the hotline?
I believe they do serve a purpose. I remember the day that we had anonymous calls, but they would still give us the phone number so we could call. And there are people that are afraid to call the hotline, even when they're educated. I get calls every day in my office, people wanting to report something, but they don't want to call the hotline because they're afraid that their name will be disclosed to whoever. And so they give me the information, and then me as a mandated reporter, I call the hotline because they refuse. I do think that anonymous calls serve a purpose. There are some anonymous calls that actually are true. I don't think eliminating them totally would be a good thing.
Okay, but they do create problems.
Yes, sir, they do.
For instance, you get calls that may be true, and you can't, because didn't get enough information or the correct information, you can't find the child or the family.
Yes, sir, we'll get a call from an anonymous caller. They'll have no address or phone number or name, so you have nobody to contact. And the reporting or the contacting information or the locating information is they receive public services, SNAP, Medicaid, things like that. With that information, you can go down to Division of County Operations and see if you can locate an address on these people. But if they don't, that's not always correct. I mean, they may get services, but they're not required to update instantaneously. So we may be looking at information that's a couple of months old. We go to that house, the people don't know them. Our clients frequently move. And we have nobody, you know, if it was a previous landlord that, you know, hey, I rented to them for a week, I don't know where they went. The people that there don't know them. You have nobody left to call to say, hey, we can't find these folks, where are they at? So it does cause a problem. Yes, sir.
Do you know of any reason personally why we couldn't get verifying information, name, phone number, and keep it private so that we could go back, either if it was prosecution because somebody was reporting things that didn't happen for purposes of harassment, or where we could go back and find information where we couldn't find someone who may be abused? Do you know of any reason why we couldn't do that and keep and get the information and keep them anonymous?
I don't know why we couldn't.
Well, you're able to do that when somebody calls you, aren't you?
Yes, sir.
Okay. Representative Gates.
Thank you, Mr. Chair. Short follow-up on Representative Payton's question. When a investigator has found someone guilty of maltreatment, or we put them on our registry and they have gone through that process and they appeal and it's overturned, the judge looked at it and said there's not enough evidence here and it's overturned. Does the department ever say, we were sorry, we got it wrong? Do we ever admit that? I think that was one of the state, was, do we ever admit? It's one thing to admit a mistake. I appreciated the investigator that said, hey, we took the hold, and after getting close up, hey, we got to send them back. That's what an investigation is supposed to do. It's not necessarily to prove guilt in a case like that. It's to get to the truth. When we get to the truth, or when a judge at least gets us to the truth and said, listen, there's not enough evidence here, do we ever go back and say we were wrong? Or is it, well, they're still guilty, but a judge ruled it, differently, but we still think you're guilty? Is that a predominant attitude that we have in the department?
I don't think I can answer the question for the department. I can only answer for the unit that I'm in. I have five employees, and it is not predominant. I don't know that we've apologized to anybody for a true finding that was overturned, no, sir.
I mean, because I know that when you overturn somebody, you said that people don't always agree with your determination because you've looked at it and you were put in a position of trust and responsibility to make those conclusive decisions. And the fact that somebody under you, we have a process by which they can appeal your decision. And when you trump their decision and when your supervisors uphold your decision, there's a point at which you have to say, I must be wrong, I don't have it. I think that concerns me that, you know, in a court of, when a jury finds people innocent, people, you know, the prosecutor doesn't come out and then say, he's guilty, yeah, we got a stupid process here. And I'm concerned that we don't ever go back and say, hey, we got this wrong, when maybe we should go back and say, what did we learn from this, so that we don't, I mean, if 40% are overturned on appeal, maybe the same points are being missed in a lot of those cases. So when we're reviewing, do we go back and look why we reviewed, and let's not make the same mistakes that caused it to be overturned on a regular basis? Maybe we need to add something in our processes to lower our turnover rate.
We do that in our individual office. Whenever we get an overturn from the appeals judge, my workers and I go over those specifically. What did we not have? Because I don't necessarily all the time agree with the appeals judge.
I understand that. I've gone through that process myself.
So whenever I'm looking at the appeals findings that the judge sends us, and we're overturned, what I'm discussing with my workers is how can we do better to gather this evidence? Because in my opinion, I don't find true on somebody that didn't do it. And we use an evidence-based, you know, Joe talked about the preponderance of evidence. But you do have to have evidence. You just can't go on one statement. There's access to the victim child, corroborating statements, physical evidence, all that.
All right, thank you.
So I try to deal with that, but we do educate our workers. And like I said, I vigorously.
I mean, for the record, I agree with you. Judges don't always get it wrong. Even Supreme Court decisions get it wrong. Doesn't mean that we have to lay down and just say they were right. But at the same time, if we're missing it because of we failed to do our job in giving them the evidence they wanted, if that's a habitual thing, then that would be a process problem. If we're giving information that the judge says this won't reach this level, doesn't reach the level, then maybe we need to change the bar at which level something's being judged by. And that may be an individual or maybe a policy. And what we're trying to find is policy. You have to deal with the people.
Yes, sir. And if I have a worker that's, if I believe the worker was consistently finding true, that would be something I would be reviewing from my end. Because I'm reviewing each investigation, and then if the findings are getting overturned, it's either something that I'm doing or that worker's doing.
You'd consider that speaks poorly of you as a manager if you have employees that continually to have be overturned for basically lack of evidence?
It would speak poorly of me, yes, sir.
All right, thank you.
One more question on anonymous calls. You said that back in the 90s they used to take the phone number.
Yes, sir.
To your knowledge, and I realize you may not know, does the hotline have caller ID?
I have been told that they have. I don't know for certain because I've not toured the hotline.
Can you imagine an office today without that technology?
Sir, my office does not have caller ID.
I was afraid you were going to answer that. You know, as we sit here representing the great state of Arkansas, so I can assure you I do. That every one of us here with the phone does. That carries one with us. Okay. I'm sitting here looking at the percentage of appeals and overturned in Garland County for 2014, and I show the rate to be for DCFS, I should say, 32% of those that are appealed, or 4% of all investigations. We have numbers in other counties that are some very high, but 3 or 4 times that. Do you think that's something that someone might want to look into?
Yes, sir.
If you were supervisor, you would probably, in those counties, you'd probably look into it.
I would.
Okay. All right, any other questions? Okay, we do not have families here today since y'all aren't used to me chairing, and we went to 7 last time. We don't have families that have come from across the state to specifically testify. It was my intention, if it's okay with you, to go till 4 o'clock. Does that suit the committee okay? So I'd like to thank y'all, and I'd like to call Cecile Blucher and Keisa Smith. Thank you, Mr. Braswell.
Thank you.
And Mr. Braswell, since you had no choice but to appear here today, because we would have subpoenaed you if you hadn't, we appreciate you coming and being candid, and I don't think that you'll have any problems for doing that. But if you should, you do have my phone number. So. If I could ask both of you to stand. Start with you, Cecile, if you would give us your name, employer, and position.
My name is Cecile Blucher. I'm employed with the Division of Children and Family Services, Department of Human Services, and I'm the Director for the Division of Children and Family Services.
Okay, and excuse me for using your first name, but Keisa, could you do the same?
My name is Keisa Smith. I'm the Deputy Director for the Department of Human Services.
And David, as long as you're up here, I don't think we're going to need you, but just in case, tell us who you are.
Dave Curley, Chief Counsel at the Department of Human Services.
Okay, if you'll all raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, this committee, at our last hearing on this in early October, had a number of questions and had asked for some information. And I believe that these statistics that I'm looking at are an answer to some of those questions. Am I correct?
Yes, sir.
Would you like to, since the question was asked earlier, would one of you like to expound on what the numbers are and where they come from and what they mean?
Sure. With the committee's permission, may I go through all the reports that were submitted and just kind of walk you through, or just specifically answer Senator Cooper's question?
Go ahead. If you want to walk us through the whole thing, that'll give us something for homework.
Okay.
If we don't get much further.
Okay, these will be the shorter sheets like this. We'll just start with those because there were a number of items requested. And the first had to do with a number of unknown or anonymous reports. And then we also talked with Senator Colin Smith and said that we probably needed to add the parent and the PRFC as a person responsible for care, just to give you that acronym, because there was some concern that a lot of reports were caught in anonymous when really in some custody issues, actually the parent gives their name. And so I wanted to go ahead and list those. So what you have before you on the first page is the total reports accepted by the hotline during 2015, with the reporter type being anonymous and then the parent. And then you can see how many were accepted.
Excuse me,
Yes,
Ms.
sir.
Booker. Clear this up for me and for everyone else. When this says for 2015, is that the 2014, 2015 year ending in June, or is that so far this year?
This is for state fiscal year ending in June 30th of 2015, so
Okay.
July 2014
All
through
right. I
June
thought
30th,
so.
15.
I wanted to be sure.
Yes, sir.
All right.
So the reports accepted for DR, the differential response during 2015 that were called in by those reporter types, are the second line, and then those accepted for regular investigation are the following line. And then you've got the substantiation rates by reporter type on those hotline reports.
I'm going to interrupt again. What does DR mean?
Differential response. That's our alternative response to some of the lower child maltreatment types. So your inadequate food, clothing, shelter, some inadequate supervision, some medical neglect, environmental neglect, those lower child maltreatment types. It's a strength-based program. So instead of going out and doing an accusatory investigation, we're trying to do a strength-based approach with the family.
All right, thank you.
And then the substantiation rate, just, I forget, we have our own lingo in child welfare. That's the amount, those that we found true. So the next sheet, and then I've got a little bit more detail on those, so if I could just go all the way through. So then we have the allegations cited for the 319 reports accepted for DR that were called in by the parent, person responsible for care. So, and then you got the same thing for the investigations. There were 2013 reports for those. So you've got more of the detail that shows what that reporter called in. So it was inadequate supervision, environmental. So you've got the actual child maltreatment allegation types listed. And then you have those same documents for the unknown and anonymous. And it kind of just gives you, we thought it would be good for you as a committee to know what are those anonymous calls, what are the allegations that people are making, whether they be the parent or the person responsible for care, or if they're the anonymous calls. The next group has the dark black legend like this. And it will be the data on the child maltreatment reports accepted by the hotline during 2015 by reporter type, because we thought it was, we needed to look at and show those substantiation rates of those calls made by an anonymous or by a parent as compared to other reporter types. And so what you have on the next set of reports is the total reports accepted by the various reporter types, those that went to DR, the differential response, those that are accepted for the traditional investigation, and those true finding rates or the substantiation rates for those accepted for investigation, so that you can see who of the reporter types may have a higher substantiation rate. But we just thought it was good data for you to have and for us to have as well, to know what are those substantiation rates by reporter type. The next sheets go to the long legal size, and this was the information that was requested. And so you have all investigations, so both DCFS and CACD, and then your next set, and there'll be 3 pages of that, and then your next grouping will be DCFS investigations only, and then your next grouping after that will be those of CACD. And so we wanted to put on the all investigations, we'll start with that one, the number of calls received by the hotline. And we did that because there seemed to be some concern that we were accepting and that we were getting involved in too many people's lives. And so we wanted to kind of draw a comparison of how many calls are actually made to a hotline versus those that are accepted for investigation, whether it be the traditional investigation route or differential. So then we gave the column that says number of calls accepted for investigation. So we'll just follow along on Benton County. So we had 3,896 calls received by the hotline. Of that, 2,080 were accepted for investigation. Of those accepted for investigations, 20% or 422 of those were found true. Of the number of true investigations, 75 of those were appealed, so 18% were appealed. Of those appealed that were overturned, 36 of the 75 were overturned for a 48% overturn rate. The reason that we gave the next 2 columns is because there has been some that have said that all of the investigations that are done, 50% are overturned. And there is that presumption that we must be doing inadequate work in 50% of the cases. So I wanted to clarify that the 48%, like on Benton County, are of those that were appealed. But if you look at those that were found true, so it would be the 36 into the 422, just so you can follow, would give you the 9%. And then the next column is 36 into the number accepted for investigations of 2,080 for 2%. So depending on how you say that, if you're saying of all of the investigations that are done that are overturned, then that would only be 2%. That's a little bit different than saying 50% of the work that DCFS does or CACD combined is overturned. And so we wanted to lay out the data in the various points as to however you want to look at it, so that when we're making statements, we're factual in what is being presented. And so that is the way that this report is laid out. Now, when you go to the DCFS and the CACD, you'll notice that the number of calls received by the hotline is not on that, because we don't assign them when they're called and we don't accept them. So we just wanted to know how many. So you will only find that on the total, all investigations. But we thought that it would be good to lay out this information. And then one of the things that has also come up in the committee is about if there is findings and they're overturned, or the repercussions for staff. You know, the issue with performance would come at the quality of the investigation, because there are times when we don't agree. Just like in court of law, there are times when you don't agree with a judge's decision. We may not either. But we do want to look at these where there are some higher percentages, and some you have to look to. If it's 2 out of 4, that's 50%. That's a little different than, 12 out of 50. But anyway, we would look at those, and we'll be asking staff. We pulled some information to know did we just have an employee that stuck out and we didn't when we noticed all the appeals? Do we have a hearing officer that stood out? We didn't see that either. So we just got to go through, and we're going to have to take some time and really go through and delve in and just kind of see in those counties that have some of the higher overturn rates to just really see, like to Tom's point, what is the practice that supervisor has with their staff on looking at those that are overturned? What can be learned from that? Is there some practice? Is there training that is needed? And so we'll be committed in doing that with these type of reports.
Okay. Representative Fott.
Thank you, Mr. Chair. Ms. Blucher, I was just wondering, with 2 agencies doing the same work, DCFS and then the Crimes Against Children Division, do you see that as a source of any possible conflicts, problems?
Well, actually, I think in some ways it avoids some conflicts in the fact that when we have allegations against a foster parent, when we have allegations against our own staff, whether that be CACD staff or DCFS staff, then we're not the one investigating each other. So I think that with the 2 agencies in that regard, it does do away with a conflict of interest, because they do all of the cases that involve our foster children, our foster parents, and then that way it's not our staff going out and investigating a foster parent that they may know. And they will also do, unfortunately, if there is a maltreatment allegation against one of our employees, then they will do that. And likewise, we would do that on their staff as well.
Well, I was actually referring to an initial investigation of a child, wondering if, because sounds like there are different requirements from the 2 agencies, if that could be a problem.
Well, we work out in our agreement those investigations that we want to assign to CACD. So they get the priority ones, those that typically have the potential criminal charges associated with those. And then DCFS does what is called the priority to those remaining that are less likely to go for criminal prosecution. I have to say that Captain Major Staten and I, we work extremely well together. When there are issues, conflicts that we have, we try to resolve those. I know that Debbie and Becky talk to each other, Debbie Roark and Becky Dunnigan. I know that there are times when Major Staten has just called Becky about issues that are going on. And so we do try to work together to resolve those issues. I mean, you're dealing with, between his investigators and mine, almost 200 staff. They're not always going to agree on different things. Ron and I have talked about the various, I know that the supervisor issue and having to sign off on the various, that the supervisor has to sign off on every entry into the system. We put that in place because we did that because we wanted to see if it made an impact in the quality of the investigations that we were seeing, because currently, or previous to that, a supervisor only had to sign off on the investigation once everything was done. And we found through reviewing near fatalities or fatalities that there were some issues or concerns with some of the quality of the investigations, that if that supervisor had really looked at everything, that maybe we could have caught some things. So if we had them sign everything, each interview, then they had to look at it more closely. So we did that from a qualitative perspective. Major Staten has got a different way that he wants to handle that with his staff, and he and his supervisors have taken the ownership of that. It's something that I think that, that he and I could review, that if we needed to go back and have their supervisors look at every contact, then we could do that. He just didn't see the need that needed to be done. And so in working with him and partnering with him, we do try to afford them some latitude, as long as that initiations are being initiated timely, that we're seeing quality investigations, those type things. And we've been willing to afford some flexibility with him in that agreement.
Thank you. What would happen if we had a situation, hypothetical here, that law enforcement said these children need to be removed from the home, and DCHS was called and you said, no, we don't think the children do need to be removed from the home? Who would ultimately make that decision, yes or no, remove these children?
Law enforcement would trump. And I know that there was a question asked earlier, I think it was by Representative maybe Payton. I was trying to write down everybody, or Representative Tosh, I believe that was you. Can we override local law enforcement? Legally, yes, we can. In practice, we don't, because you're out there, you respect their position that they have, you're trying to keep a good partnership and working relationship, and so most often we will defer to them on that decision.
Thank you.
Okay, Representative Gates.
Thank you, Mr. Chair. I think, just for clarity, I know for me, when I hear the statistic of the overturn rate, it's always associated with those on appeal, because you can't assume just because it wasn't appealed they agreed they were guilty. There's times I've paid penalties I disagreed with, and I've even paid penalties or something and wrote a note, I disagree with this. I paid it because it was a lot, it wasn't worth the process. So I don't think that the lack of appeal, we can assume everybody agreed that they were guilty. But when we find the statistics of those that are appealed, with the understanding that when something's appealed, there's going to be a lot more scrutiny put to it. Another set of eyes is going to put on it, maybe some legal eyes, maybe somebody who's fixing, that is not willing to have their ruling overturned. So I think it would be a wrong assumption on our part to assume just because it wasn't appealed that parents necessarily agreed that it was factual. I guess my question is this: what percentage does the state deem acceptable for an overturn rate? What percentage is the state comfortable with saying we've done an adequate job? I know in elected officials, if a decision was overturned 40 or 45% of the time, in 2 years, he would be turned out by the voters because his opponent would take a billboard and said, he is overruled by the Arkansas Supreme Court 45% of the time. That's not an acceptable percentage in local government. What percentage are we aiming for to try to lower that number to, and at what point do we say this isn't cut?
You know, we've not established a rate or a percentage within the agency that I'm aware of. You know, I know that we do have concern about the percentage that is there, and so it's really just delving into why are those percentages like they are? Why is it in those?
Total number of appeals, overturn rate, and the percentage of overturn rate, and I look at district, District 9. I don't know what District 9 is, but District 9, it says 70% of those were overturned. And this was a document that we've gotten from you guys. I assume it came from you guys. I had an employee this morning come to me and say, you know, Mr. Gates, you gave me a report, and it's missing my largest customer. I don't know why, and I was the one that made the report. He wasn't accusing me of trying to defraud him of anything because he had been paid everything off of that. It's just somehow when I ran the report, I missed some of the very factual data, and in this guy, it was one of his largest customers. When we're running data, especially for us to make major decisions on, how reliable are these numbers and by what criteria, so that when we're making decisions, we're able to look and see how do we fix a problem without creating worse systems, but how do we fix the system? And how accurate can you assure us that 6 months from now or 2 years from now, we don't say we made wrong decisions based on wrong data?
And I can respect that question and that concern, because one of the things that we have seen is, you know, the appeals and hearing has their own database. Then we have the information that comes over to us based on their decision, and it's put into the child maltreatment registry. And one of the things that we've seen is that right now, if you took our data, you're comparing apples to oranges. And so we've got to find a way to crosswalk that data so that we can provide to you as a legislature the correct numbers to make your decisions on. And so we've got to find the way to crosswalk our data.
In our last meeting, I believe you were here at our last meeting, somebody testified that after the 6th time a custody hearing had put on hold because a mother had called the hotline on her husband, after the 6th time being found innocent, the judge finally said, don't do this again. First of all, I question why that judge is so slow, that it would require 6 times and how many years of, you know, prolonging those proceedings, and how much money did it cost us taxpayers when somebody could have very easily said not substantiated, don't do this again or we're going to prosecute you. But it took 6 times and we still haven't prosecuted that person. Are we looking at in our processes with all the light that's coming on that we knowingly know people who have used the process to take away our time, energy, and effort of investigating people that they know is false or erroneous, thus taking away money, people, resources to really investigate the ones that really need to be looked at? Are we looking at our policy after, you know, going after those people that use the system?
I think that we need to strengthen, you know, so that people are as diligent about doing that as Tom has been in Garland County. That's something that we can go back and kind of look at and just see what is the process across the county. If there is reservations and people doing so, what are those? And then bringing that in, let's discuss how we can remove that barrier.
I mean, we don't need to put a fear for people reporting wrongdoing. We don't want to go that route. But at the same time, people need to know there's a penalty.
Representative Gates, we need to.
Thank you. Sorry about that.
Representative Fott.
Thank you, Mr. Chair. I just need to follow up with what I asked earlier because I'm not sure I'm totally understanding. If the local sheriff or a local policeman perhaps in a city says this child or these children need to be removed from this home, and the DCFS worker with all of the training and experience says, no, these children are not in any imminent danger, the opinion of the law enforcement person trumps, that concerns me.
I think in a number of the counties, that the system would probably defer more to the law enforcement. I mean, I think you've got staff that would be willing to engage in that debate, that discussion with the law enforcement. But you also have to depend on them to, when you're like Mr. Braswell's example, that if a family doesn't let us in the home, then we've got to defer to local law enforcement to have them come help us in those situations. And so you've got to, I guess, for lack of better words, pick your battles. And because you're trying to preserve all the relationships, because you've got to work with everyone, law enforcement, the courts, everyone.
Well, I'm just more concerned about the children in that situation, children being uprooted, moved from their home when it's not necessary.
And I would agree with you, and I think that that's why there would need to be that conversation between the DCFS staff and the law enforcement and try to really work through that and really talk about the trauma. And I do agree that there is probably more training that needs to be done in the law enforcement realm. I think that was a very good question to ask. What are those training differences between the removing authorities?
You done? Okay. Thank everyone for being here. We will, Karen, I would like to be sure we have this again for our next meeting, that everyone has a copy, so that we can further look into this. One of the things that I would like for us to consider from this chart that I think we need to look at is Representative Scott and I agree. I think we would all agree that we would like to have no child anywhere, not just in Arkansas, but anywhere, harmed or abused. Having said that, if y'all were to knock on my door, you would get a much different reception from knocking on Representative Scott's door. And I'm not any more likely to be guilty of child abuse than she is. So we do differ on that. Because I would resent the state or that someone else thought that I wasn't parenting properly or grandparenting properly. But that being said, and then the reason I said it is if we were going to try to make sure, if we were perfect and we were able to make the right decision in every case, the only way I think that we could find every child that might be being mistreated would be to go to every door. And so that is one edge of the question is if we were to do that, one, that would be very expensive, and we're always talking about money, and two, that would be very invasive. On the other end, if we don't go to any door, then we're going to have lots of children that we don't help, but it'll be cheap at least on the state tax end, and we won't be invading anybody's home, the sanctity of the family, or violating their constitutional rights. So in saying that, at the very top, and there's no page numbers this time, so on the 8.5 by 11 down where we had the dark black on the top, where it's got the unknown anonymous, which is where we get the most calls. And as I go through every agency, and the question I always like to ask is, what are you doing where we spend the most money and we get the least return? I look right under that and I see 4,594 calls from law enforcement, and that's 45.3% substantiation rate of those that are accepted. But right above it, the one we get the most of, 6146, then we actually accept 5134, 18.2% of our calls. We only get 11.5%. So how many doors do we want to go to? And how do we, because the answer always comes back in government, more money. And the answer might not be, again, we could keep saying more money until we go to every door. But are we spending resources in an area where we're trying to save every child, but we're possibly, the resources would have been spent other places, and we wouldn't save other child, and we're not going to save other child. But just, that's something I would like to look at in addition to the other questions that we've looked at. Tomorrow, we will be back here at 10:30, and we will go, we're shooting for noon, no later than 12:30 as far as the meeting tomorrow. Absolutely no later than 12:30, and we will try to get out by noon. But what we're going to look at is the financial impact and benefit to donors for removing taxes on charitable giving. Right now, most folks aren't aware, most legislators aren't aware, most retailers are not aware that if a retailer gives merchandise to a charity or government organization like a school or volunteer fire department, the state wants them to pay the sales tax for the stuff they gave away. And when a retailer is audited or a business is audited, if they are a big giver, they screen. But it only happens one at a time. And that's why most people don't know about it. And so we're going to look at that tomorrow. We're going to look at, what kind of tax money do they say we're getting from that? How much are we really getting? And it doesn't show, yes it does, number 4. Representative Mickey Gates will be testifying as a businessman who's been audited, who gave stuff away. And to give us I hope that you'll be here for that so you can get the perception from someone who's been through that. And do we really want to put a disincentive on giving to schools, fire departments, charities, etc.? Because if they give the cash, there'd be no tax. It's only if they give merchandise. So that's what we will be doing in the morning. We will be coming back to this subject on child maltreatment at a later date. Thank all of you for being here. And with that, no one else, we are adjourned.